I mentioned a matter, my lord. The matter pertains to green.
This is the case, my lord. In fact, yesterday this court had given the date. This is the writ appeal against the orders of the London single judge lord. The land was granted to this appellant's father, and only after the London single judge has, without appreciating the provision of section 4(2) of that PTCL Act, my lord, the writ petition has been dismissed. Again, that writ appeal filed, my lord. In fact, yesterday this court had given the date 6th, my lord. It is not posted, my lord. 6th dates, this court had given the date, but it is not posted. I am requesting this court to post it on Monday, my lord.
To be verified then. It is going to be posted today.
But Monday,
It was going to, no Monday. It was going to be posted today.
yeah, Tuesday or Wednesday, any can.
The matter was supposed to be posted today.
Yesterday, my lord. Yesterday, sorry, my lord.
It was not
6th.
posted. You check it.
Yeah, my lord. Moment. Yes, my lord.
My lord, the matter pertains to green bench wherein the NGT has imposed a fine of 100 crores, my lord. That is before challenge before this honorable court. The matter was supposed to be understood that matter will be listed on 28th of February, but online the date is on 28th of March, my lord. The matter is listed before NGT Chennai, my lord, on 19th. That is the reason maybe taken up on Monday, my lord, Monday or Tuesday next week, any time, my lord.
I'll lie.
Please.
Order challenging the order of the single judge, my lord. In this, the subject lands were gifted to the petitioner for the welfare of the Anjaneya temple, my lord. But the Archakas who came there set up a plea that they are the grantees, and now they are giving it to the real estate agent to dictate, my lord. The Tahsildar as well as the deputy commissioner have quoted that the grant is illegal and also all bogus documents. I have challenged before the single day saying that this I was not made as a party because I am interested party in this, my lord. But they say that I am no custody. Now I have challenged this petition for plenary.
It will come. Not by memo. No urgency.
Point to direct.
Yes.
Contempt petition. Senior citizen.
Yes. What do you want?
I am saying that they are digging the land to make the real
It will
estate
be
development.
We post. Wait for a week. Yes.
Directed to settle the pension and other benefits within a period of 8 weeks. So far, there is no compliance with the order, my lord, despite filing the.
3rd April. Pardon? Pardon?
We are challenging the judgment of the higher court, within the court has set aside the arbitral award and allow the petition filed under section 34 of arbitration. So the urgency at present is that the responding hearing or entire information will be judged.
It will be posted. Wait. No, not by memo. Yes. It will be posted. Remove the office of objection will be posted. Then no point in mention. Wait till it is posted. Wait for a week, then mention if it is not. Every matter cannot be posted by memo. Yes, unless there is urgency. Yes. Maybe in every matter there is a stay application. Yes, next.
Appeal, madam. Connected contempt petition is posted on 14th, madam.
14th.
That belongs to
14th. 14th.
So one commercial appeal has been filed by me by challenging they come for the disobeying the that interim order. We already obeying the interim order. We already added their name to the title of the film, but then after the day before yesterday, they go for that contempt petition before the trial court. So I filed
You filed it.
14th and has been given the date for they are filed the order 39.2 for the disobeying the interim order of adding the name in the.
Before the trial court you filed. You filed before 39(2)(a) before trial court.
That has been filed by the plaintiff. I am in that defendant.
So what do you want?
I want to state a proceeding of that trial court.
It will come. No, not memo, not by memo. Yes. Yes, Mr.
Your Lordship, serial number 32, 2 writ appeals have been filed, Your Lordship.
32.
32, Your Lord. To be tagged along with it. I'll inform soon. I'll inform them also.
What do you want?
Your Lordship, 2 writ appeals have been filed.
So their file, they're coming up when?
Yes, Your Lord. No, it has to be tagged with that piece of paper.
Coming up when ಅಂತ ಇದೆ.
Coming up with scrutiny is there, type of has to be for a week ಮಾಡ್ಬೋದು.
If they are coming up on any date, then we'll.
No,
post
date has
it.
not been fixed.
Date
Date has not been fixed.
What is the number that is given?
Rate appeal numbers are
Three-
there.
So we listed with
334 of 25,
334 of 25.
25 and 332 of 25.
Writ appeal number 335 of 25.
334, Your Lordship.
334 of
25
and 335 of 25.
332 of 25.
334 and 332 of 25.
Yes, Your Lord.
Are filed which is against the order, which is subject matter of the contempt petition. In that view, the contempt petition shall be listed along with the said appeals.
Much open.
But remove the office objection.
Yes, sir.
Don't keep it lying.
No, no, we will. Only translation is pending, Your Lordship. Much open.
My lords, what has happened is in the tenants dispute, my lords, and for the tenant, my lords, the landlord, my lords, there's an apprehension that he may alienate or my lords give up with property, which is the subject matter of the dispute. My lords, this is a invalid termination of contract.
Section 9 proceedings.
My lords, this is a 37, my lords, it's an appeal. My lords, all objection have been removed. My lords, I'm just seeking for an early hearing because effectively, my lords, ultimately the appeal will be rendered infructuous if they take any steps towards alienation.
19th of March,
Be clear.
Milord,
27
serial-
and 28.
20,
27 and 28. Both are similar matter. For a happier, then
27 and 2 years. What do you want?
we are for the complainant matters. Pray for a short of,
It will go to 9th April, both.
Milord, serial number 13,
To 9th April as requested by, on behalf of the complainant.
item number 13, Milord. Item number 13,
26. Go to 9th of April as requested by learned petitioner.
item number 13, Milord.
13.
This, Milord, with regard to challenging the section 128A of the Karnataka Societies Act.
There is a
Milord.
delay of 65 days.
No, the connected matters, Milord, the very same judgment, against the same judgment, Milord, the government has also prepared the appeal and it was entertained. And matter, Milord, is ordered to be listed on 25/3/2025. May be taken up along with that matter, Milord.
Very well. You don't want notice in this.
Notice can be
Notice
ordered, Milord, the
returnable on
government.
9th of April.
Government for 1, 2, 3, Milord, rest of Milord, caveat is there,
When that appeal is coming up.
25/3/2025.
Then 25/3 to be listed with writ appeal number
1484 of 24.
1484 of 20.
R4 to R8, Milord, standing counsel is there, Milord, I am permitted to serve the,
So,
please. Much of.
Inform the other side. as well, same. The interim order may kindly be extended,
21 writ appeal 1575.
157.
So yours, what is your good name?
The Goud,
You are for appellant.
and for the other.
On behalf of the appellant, learned so and so, so request for time. When shall we keep?
Any day in the first week of April.
8th of April.
The similar writ appeals, my lord, and
Interim leave granted earlier shall continue. Let it go to then 15th April. Madam, 15th April. 15th. First, remove the office objection.
5, 6. Serial number 5, 6, 7, 8,
That water contribution, 9 also.
5 to 9,
5 to 9 all?
5 to 9, 18.
5 to 9 all?
5 to 9.
7, 8 also? No, 7 and 8 also?
Yes, my lord.
All.
5, 6, 7, 8,
So all
9.
will go to,
20, 21 is also there.
all will go to 15th of April.
And 703 is not listed, my lord. That was the appeal preferred by the
50 to
PWC.
66.
Has to be.
I will be
permitted
to take notice on the basis.
No, let it all listed on 15 without looking at that water contribution charge.
Water.
Water
Water
contribution
charge.
charge. Let it be listed on 15.
52.
Same, 50 and 60.
52 also. 52.
Give the number to the
I will pass on the number.
court officer. All
Connected,
will-
I'll pass on the number.
all will list.
Standing counsel.
42, serial number 42, madam. Seeking for the slot accommodation.
It will go to 16th of April. 45. Is what shall be done.
45 minutes.
What is the request?
I have to file the wakalat. I have to file the wakalat minutes. Kindly 2 weeks time maybe.
45.
Please.
It will go to 23rd of April, as requested by learned so and so, to enable him to file the wakalat. Yes, anything? File. That matter. Take up
Any mention?
contempt.
Your Honor, triple C 259 of 23. This was, I had filed IA number 1 and 4 in the month of January 2024 and February. Based on, there was an error of 20,000 calculation error, and plus there was a disobedience of the contempt order also. So today it was supposed to be listed, but it has not come for the hearing.
Give
sir.
the number, we will verify and post.
And since December, it is on stand on, yeah.
Verify. Just, what is, yes, next.
Any mention through VC, sir?
That contempt. 36, not to be placed before the bench where one of us, Independent Honorable Mr. Justice M.I. Arun is a member. 36. No, contempt. Lady.
Number 1 to Bal Gangadhar GS.
Your Lordship, appearing for petitioner 3 and 4, sincerely, the foremost thing, my apologies to cause inconvenience to this honorable court, Your Lordship.
You're not interested in apology, but you do the remedial thing. This affidavit can't stand on the
Your
record.
Lordship, kindly allow me to withdraw this as not to press, and I will file the better with. Actually, Your Lordship, my humble submission, only one submission I want to put in before Your Lordship. This was not the exact affidavit. Please, if you could see the para number 5. I had discarded already this. This is a clerical mistake where my clerk has gone ahead, and para number 5 states that I further states that the averment made in para 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17. Partly true. So seeing this itself, I have discarded this, that this should not be filed. But unfortunately, the clerk has inadvertently filed this. So it is my sincere apologies, Your Lordship. Better copy, which
Affidavit dated 27. When the present contempt petition comes up for consideration today, learned advocate Ms. So-and-so, appealing the petition, seeks permission of the court to permit her to withdraw. Affidavit dated 27/3/24, affirmed by one Sri Abdul Rahman, son of Abdul Karim, stated to be holding the post of principal, Hazrat Madar Shah ITC and D.Ed Training College, Ashoka Road, Tumkur. Permission is granted. The said affidavit stands withdrawn and discarded from the record of the court.
Now, my lord, my humble submission is, IA1, my lord, to recall the order, my lord, may kindly be allowed, it may be restored. Because, my lord, they have withdrawn the compliance affidavit. Now, my lord, my humble submission is about 60-70 lakhs back wages they have to give. My lord, I have read the entire contents, my lord.
Better if the fresh learned counsel for the petition seeks time to file another affidavit. Stand or two.
Please.
Well, when shall we keep? 9th of April.
My lord, my lord, my humble submission is this, my lord. One of the complainant, my lord, virtually, my lord, she is suffering a much, my lord, hospitalized. Kindly grant me short date, my lord. My lord, what has happened on the earlier date? My learned friend has no courtesy even to give me a copy. I took a certified copy from the honorable. Your lordship was kind enough to consider and close the matter. They did not comply with it, my lord.
Your lordship, this we'll serve the copy first and then we'll find.
No, it's not.
Unrelated for this
IA1 may kindly be allowed.
6%, not petition.
But I1 is allowed. They,
Early,
We'll serve the copy, your lordship, and then we will file it.
early is 20,
week after next, my lord.
2nd April.
2
Second.
weeks time, your lordship. I
Second.
need to calculate because there are orders in the.
Second April.
Maybe.
It's festival, your lordship. After that, any date would be fine, your lordship. Is given 7th or 8th of the April.
When it gets over.
2nd or 3rd, maybe the Eid, your lordship, of April.
Eight. They
Please.
They're responding for compliance.
That may be recorded, kindly.
No, this is the contempt proceeding. They'll be responding.
Yes, please, I am much obliged. Both the matters, my lord. Both the matters.
Both.
There is a dispute in the calculation according to the order of WA 121, wherein we were supposed to, respondent was supposed to calculate because they are giving a sum of 55 lakhs, so 1 crore. It's an ITO run unaided, run by a madrasa and an orphanage. So exorbitant, that was the main dispute. When we have taken this SLP, we filed in Supreme Court, orally, your lordship has guided, stated this, that the statements which we were not recorded in the High Court.
But all said and done, you should have checked the affidavit.
Obliged.
Really offending.
Please.
It is only, you are served only because your colleague, junior colleague gave it.
Honorable court was majestic. All these grounds, they never made earlier, my lord. Please. Both the matters.
Sir, PL matter, still number 3, GM Nataraj.
Please. This is a petition challenging diversion of land of the Agricultural Produce Marketing Committee for construction of a public utility mall cum parking lot. Lord, my respectful submission is the violation, my lords, occurs on 3 steps. First, my lords, non-compliance with certain provisions of the APMC Act itself. 2, my lords, the land gets transferred to the smart city, Tumkuru smart city. But my respectful submission is development of a mall is in violation of the objectives set out for smart cities. For development of a private mall in a city violates, my lords, Article 21, read along with directive principles. If your lordship, my lord, will kindly see annexure K at page 181.
What is TSCL?
My lords,
Who is
Tumkur Smart City Limited. It's a government corporation, special purpose vehicle, my lords, incorporated for the purpose of developing a smart city. It is set up under the aegis of the Central Smart City Mission. And volume 4, my lords, page 630 are the details of Tumkur Smart City Limited.
This is the land of APMC.
Please note,
Now used for construction some mall
please note,
by the Smart City Corporation.
by the Smart City Corporation.
APMC is not coming for. APMC has no grievance.
Notes, my respect submission is APMC has consistently said that they need this land for a cold storage facility. Not my respect.
For APMC.
Initially, my lords, APMC said we need it for a cold storage facility. Thereafter, my lords, a meeting is convened by the deputy commissioner, in which they are told, let us prioritize commercial development over cold storage facility. My respectful submission, my lords, is that it is contrary to the APMC Act, what they have done.
But then this land is transferred to this corporation by virtue of some deed,
Lords,
agreement
there is an agreement, my lord. There is a tripartite agreement between, my lords, the APMC, the government of Karnataka, and the Smart City Corporation. And at the second level, my lords, building of a mall is also not in accordance with the objectives of the Smart City mission.
Who are you?
My lord, petitioner number 1 is an organization. I am the convener fighting for rights of farmers. Petitioner number 2 is an advocate practicing in Tumkur who is also in social service.
What is annexure B for photographs?
Lords. But annexure P is letter of secretary.
No,
APM.
B photographs, B photographs.
Please, my lords.
126. Page
Lords,
126.
it is only to show participation in various activities.
In this activity regarding this,
Not generally social service activities, not of petitioner number 2 participating in various social service activities. Show, my lords, that he is a public spirited individual.
this is not in Karnataka.
One of the photographs is not, my lords. It's in Tamil. In paragraph 13 and 14, my lords, these are pleaded. Paragraph 13 and page 31 is the pleading in respect of these photographs.
There is no statutory kind of violation.
My lord, there may be, my lords. If your lordship will please see annexure K at page 181. The land in question comes to be decision, your lordship will please find at page 183. My respectful submission is this violates section 6, 9 and 63 of the APMC Act. Page 163, if your lordship, my lord, will kindly see. Page 183, my lords, I am sorry, bearing notification number so and so, the area within the boundaries of Tumkur municipality and Batwadi village was declared as a market area. The area within the boundaries of Batwadi village comprising so and so, and vide notification dated. Lord, 6 lines from top, that's the relevant portion. And vide notification number dated so and so 23/2/2005. The area measuring 53 into 110 square meters to JC Road in Tumkur town, regulated agricultural produce. This, my lords, once a property is declared as a market subyard within the meaning of section 4 of the APMC Act, then, my lords, my respectful submission is it can only be excluded by way of a notification. And the purpose of exclusion should also, my lords, be in accordance with the object of the Karnataka APMC Act. That your lordship will please find in section 6, subsection 3. And my lord, section 9 requires that such an exercise must, and 63 says that every property of APMC shall be put to use for the purpose of efficiently carrying out the duties of APMC. And my respectful submission is it is no part of the duty of APMC to participate in a mall project.
Really should not.
Great.
There is a decision of the Gujarat High Court,
Please.
where probably the APMC land was in that case probably sold off and utilized for construction of
Five-star hotel.
that's,
Please.
and that was upheld by the Supreme Court.
Please, I will distinguish that judgment.
The bench of Honorable Chief Justice D.Y. Chandrachud, as he then was, I believe that subject to correction is up.
I will check that.
Notice returnable on, it's 7th April.
Great.
Learned additional government advocate Srimati Nilofer Akbar accepts notice on behalf of respondent. Full stop since, yes, 1, 2, 3.
Okay.
1, 2, 3, 4 and 5. 1, 2, 1 to 5. Since the grievance of the public interest petitioner is that the land of the Agricultural Produce Market Committee, which is declared as market yard and forms part of the market yard under the APMC Act, yearly year, is sought to be put to use for construction of contents are directed to file the reply before the next.
14. I accept notice for 14. Respondent.
You are for 14.
Please.
And learned advocate accepts service on behalf of smooth paper. The rest of the respondents will be served. Then lastly.
Great.
This is number 4. Agree. Matter to Guru Prasanna.
Okay, for the petitioner, my lords. This, my lords, I am, my lords, the neighbor of a unit, my lords, in a residential area. The respondent number 3, my lords, is running a private establishment. It's a shop, my lords, or at least that was what was running earlier. Subsequently, my lords, the respondent number 3 has turned it into a full-scale manufacturing operation in the residential premises itself, which has caused significant harm to the petitioner. Photographs of the kind of pollution that is being caused, my lords, are 26, 27. In this regard, my lords, I have submitted representations repeatedly to the respondents 1 and 2, my lords, to look into the matter. I've also filed a necessary application under the RTI Act, my lords, to see under what are the permissions that have been accorded to the respondent number 3, my lords, to carry on a manufacturing activity inside a residential premises. They've not taken any action, my lords, hence I'm seeking a writ of mandamus, my lords. Simpliciter.
Notice written. Doubt he is saying that somebody is operating from the residential premises.
But what we understand is that this should fall under the green category industry, assuming it is also all white category industries, and consent may not be required. In any event, whether if there's any
Whatever
other activity which is
not at this stage. Notice returnable on 8th of April.
5 to 9 are urgent. Bill number 10, writ appeal. So P. Mahesh.
I appearing for appellant, my lordship.
Nothing wrong in the order.
My lordship,
Remedy
it is wrong, opposite to the full court judgment of this honorable court. My lordship, kindly see, I am purchased the property in the year 2002. And later, my lordship, there was a civil suit. In the civil suit, my lordship, the state is also party. I have been declared as a owner of the property. Owner of the property. My lordship, I have produced those documents, my lordship, kindly see at page number 79, my lordship. page number 79. Suit of the plaintiff is hereby decreed. Plaintiff is the absolute owner of the property bearing survey number 21, measuring 2 acre 20 guntas, situated at Mariala village, Kasba Hubli, Chamranagar Taluk district, bounded by east so and so, my lordship. When the court has so dismissed, my lordship, which is reached finality. My lordship, when the civil suit has declared me as a owner of the property, and I have a valid title deed of sale deed, registered sale deed, produced before the revenue authority. It is the duty of the revenue authority to enter my name, my lordship. Kindly see at page number 160, the endorsement issued by the Tahsildar. It is contrary to the civil court order.
This judgment and decree is final.
I'll secure instructions, my lord, regarding.
This is on the way of registered sale deed, they are claiming the.
Yes, my lord, there are suit.
Full court judgment of this honorable court, my lordship.
So this order is passed by Tehsildar.
My lord, the order is passed by the Tahsildar, my lord, which is at
Tahsildar
page number
goes
160,
behind-
my lord. 160 is the order.
One page.
Page number 160 is the translated copy of the
Translated copy of the endorsement
endorsement.
issued by
my lord.
the
136(2), you have an alternative. application.
Alternative remedy.
Lordship,
that is-
kindly see, my lordship, earlier proceeding, my lordship, which has.
Sir, whatever it is, sir, it is an order passed by Tahsildar. You have an appeal remedy under 136(2).
Tahsildar cannot, my lordship, under 226 of this one.
You go same thing before the assistant commissioner. Why are you rushing to the high court?
They want, my lordship, the party should not be dragged to the litigation unnecessarily, my lordship, because this honorable court, full court judgment of this honorable court clearly states that, my lordship, it is the duty, my lordship, when they have violated their duty.
Fine, agreed. Say the same thing to the assistant commissioner. He
Lordship,
will
why-
look into it.
My lordship, suppose they have dismissed my appeal. No, this is dismiss appeal.
136(2) or not?
No.
Why?
Endorsement may kindly be seen, my lordship. It is not issued under any other provision of the law. Kindly see, my lordship, at page number 160.
Now the ground is you are producing the fabricated Sagwali check.
My lordship, how can he say that fabricated
Not
when the
possible
civil
to-
suit has been concluded in my favor, wherein, my lordship, state is also party? How can he fabricate that document? He has no jurisdiction to say like that.
Then you raise that as issue before the appellate authority.
My lordship, even before the land single judge, my lordship, I have raised every ground.
Now,
I have
given-
produced all the documents.
Given the ground and the findings of the Tehsildar, it is a case to go before the appellate authority only.
My lordship, not appellate tribunal, my lord.
Appellate authority, given the nature of the findings, producing, Pata has been made by producing fabricated Sagwali cheats.
My lordship, in the year 1975, land has been granted into my vendor.
Mr. Mahesh, with
Yes,
your
ma'am.
experience.
My lordship, my respectful submission to this honorable court is this: the Tahsildar should not be given right
It's an
to
order.
go beyond the civil court
It's an
judgment.
order. Yes, correct. That
Yes,
is the
ma'am.
correct proposition of law.
Yes,
It's an order passed under section 129 of Karnataka Land Revenue Act, correct?
yes, my lordship.
It's an order
Yes,
passed
my
under,
lordship. Let it be, we think that 129 itself.
no, it's under 129.
Yes.
When an order is passed under 129 by the Tahsildar,
My-
appeal automatically lies under 136
Maharaj,
too.
On the basis of this honorable court, mandamus issued by this honorable court, mandamus, my lordship, kindly see this honorable court. My lordship has passed an order directing the respondent authority to enter the kata. Mandamus has been issued, my lordship, this honorable court. Kindly see at page number 157. Petitioner is 80 years aged man, my lordship.
So why should you bypass the appeal?
My lordship,
Why should you bypass the remedy of appeal?
now, my lordship, kindly see, I have quote, my lordship, as clearly, my lordship, this honorable court, full bench judgment of this honorable court has stated so, my lordship. "80 years old petitioner, my lordship. 80 years old, my lordship, he has spent his lifetime, 30 years in the litigation. Again dragging this honorable court for the litigation, my lordship. It is not fair on judiciary also. My lordship, because the status of the party also is looked into. Because, my lordship, he is 80 years of old. When he was in the 50s, my lordship, he has purchased this property. And the name of the vendor. And vendor, my lordship, has sold the property in the year 2022. Later, my lordship, they have raised the dispute. When entering Kata in suit. When exhausting the remedy by the Tahsildar, my lordship, when he is discharging his duty, he has erred in all sorts of legal aspects, my lordship. Should we encourage one more litigation, my lordship? Look in court, and who was having the valid title deed, just because something for their own wishes, my lordship. A magistrate court also says that go before you have alternative. That is not fair, my lordship.
Ask the legislature to abolish all the courts, tribunals, everything, and have one high court.
My lordship has very well aware, my lordship, just because not this honorable court cannot invoke Article 226. Lordship, a lot of judgments are there to that effect, my lordship. Just because there is an alternative remedy, the hands of the honorable High Court is not tied. Supreme Court also said so, my lordship. Because, my lordship, only in extraneous circumstances this endorsement has been issued. Because, my lordship, they want to grab, somebody want to grab my property.
You will direct them to condone the delay in respect of the time spent by you in the High Court.
My lordship, if this honorable court has no jurisdiction and it has no powers under Article 226, my lordship is right. I have to approach. My lordship, civil suit where the title has been clearly discussed. I have produced the judgment also kindly. I will read the findings of the civil court. It is not an ex parte judgment also. It is a contested suit. 80 years, my lordship, my client. Already 33 years he has spent on the litigations.
What
97, paragraph 97 of the full court judgment, my lordship, but I have passed. Kindly. In view of the, my lordship, paragraph 97, page number 1583, I'll go to the straight away the point, my lordship. The entire judgment is only on the point that whether the revenue jurisdiction is more than the civil court or 97, paragraph 97.
Where is that? 97.
1583, page number 1583.
There is no 158.
Let's kindly see. I maybe
There is no such page here.
I have
Give
a
to
digital
him,
copy
don't
also.
waste the time, like him.
In view of the provision of section 135 of and 62B of the Karnataka Land Revenue Act, a party can approach the civil court interested or to deny his title for the relief of declaration of his right to establish his private right, and any declaration made by the competent civil court will be binding on the private parties as well as the authorities concerned. Who passes the orders? Binding. Who passes the orders under section 136(2) and 3 of the Karnataka Land Revenue Act? It is settled that any adverse petitioner here, the Tashildar, with regarding to the record of rights in respect of the private parties or any entries exercised their power under the provisions of section 136, chapter 11 of the Land Revenue Act, it shall not be binding on the civil court as well of any decision made by the authorities under the Land Revenue Act, only with regarding to the land revenue, assessment and collection of revenue, maintenance of the records, survey of the revenue purpose and records of rates only. The authorities under the Land Revenue Act have no jurisdiction to decide the title between the parties suit, invoking the provision of section 9 of the Code of Civil Procedure, subject to the cause of action of when arises. Therefore, the question 3 under the reference code raised. Question 3 is raised for the purpose of whether the civil court as revenue court can go beyond the judgment of the civil courts. In this instant case, my lordship, the Tashildar gone beyond his jurisdiction. He says that, my lordship, I have produced the some fabricated document. How can he come to such conclusion, my lordship, when the civil court straight away, my lordship, the civil court has given a finding to my documents, and I am the owner and owner of the property. The civil court has the revenue. The Tashildar has no right to say like that and issue such an endorsement. Therefore, my lordship, the Tashildar should not be given more powers than what the civil court has done. Hence, my lordship, this honorable court under Article 226, my lordship, it has got every right to correct that error apparent on face of the record has been committed by the Tashildar. Therefore, my lordship, I respectfully pray this honorable court to give a direction to consider my enter the kata based on the civil records. If my lordship is are not satisfied with my submissions, my lord, because 80 years, my lordship, he has spent about 30 years in the legal proceedings. Despite of this honorable court feels that, my lordship, I have no case.
Except legal submissions.
That's what.
We discourage all such comments, observations, which are beyond legal submissions. Yes,
Yes.
and you are sufficiently experienced, seasoned advocate. And we don't not only encourage, we deprecate. There any observations,
Sorry, my
comments
lord.
on the court, on the matter, on the advocate? Stick to your legal submissions.
In this matter, my lordship, what happened, I am.
So what do you want? Do you want an order or do you want this, that this court should not take up your matter? Where you are
I'm not, my
the
lordship,
way you are concluding the matter,
my lordship, kindly see, withdraw, not for the argument, only for the permission to seek for a withdrawal.
learned senior.
Because,
after some amount of arguments, 6 times, stand all to 25th of March.
Seal number 11. Sumati Pauline.
There is a delay of 707 days.
The delay because the respondent had.
Notice returnable on
Yes. Oh,
7th April.
Seal number.
There are two more IAs on that, my lord, 2 and 3. That is for production of documents.
That will be considered at the time.
Yes.
Okay.
Seal number 12. Pradeep S. Saukar.
For the appellant.
This is also delay of 82 days.
No,
You are appearing
he's on caveat.
Caveat.
in KVA.
Not the issue relates to an order of promotion being given on the basis of, my lord, a certificate which was not recognized. And it was not the institution which issued that diploma, PG diploma degree was not recognized, was neither affiliated to.
Will condone the delay or learner and every respective parties. IA number, known as below 72 days. 82 days. 82 days. Full stop in the accompanying affidavit. The passage of time, paragraph in the accompanying affidavit, passage of time leading to the delay to the requisite extent is explained with following government, extracting the same from paragraph 4. Bracketed portion, page 101 to, it will end up to the aforesaid
2012 notification.
reasons spelled out, make out that the grounds for delay are administrative in nature, element of negligence or indolence on any part of the applicant or its officers is not indicated. In that use of office is made out, delay is gone down. Now, today to be taken up or appeal to be taken up today? Yes,
My lord, annexure E, your lordship kindly take,
yes.
page 59.
Annexure.
Annexure E, page 59. My lord, there is a circular which provides issue Vidya Bhavan Rajendra Prasad Institute of Communication and Management, Mumbai will not be considered as recognized professional qualification for the purpose of recruitment and promotions. Now, my lord, it is on the basis of the certificate issued by this institution that promotion was inadvertently granted. That has been withdrawn. This is of an office memorandum which was issued by the government earlier regarding equivalence. Without noticing this circular issued by the management, proceeds to hold that this this is not under challenge, my lord. This was not challenged. This circular which was issued derecognizing the certificate issued by Bharti Vidya Bhavan. In fact, my lord, before issuing this, the vigilance conducted an inquiry and found that that institute is affiliated to AICTE or UGC. Now, my lord, it is only when it is recognized by either AICTE or UGC, or the degree is issued by any university to which this institution is affiliated, that we recognize it as a degree or an equivalent.
Page 64 order was passed after hearing the input. He was already promoted.
Yes, my lord. This promotee, now, my lord, the promotee was working in the same department. Now, my lord, she is the one who included her name for promotion on the basis of certificate that she has obtained without noticing the 2012 certificate.
That is right, but you heard him or not? So that minimum requirement probably supposed to be willing the promotion on a maybe on a good ground according to you, but
Here,
he's suffering a serious civil consequence. So you are cancelling the promotion and also withdrawing the recovering the financial benefits. June 14 now. That's according to us one of the aspects to be dealt with.
Yes, I just find out, my lord, whether a hearing was given before issuing this, my lord, and then make my submission.
27th March.
Obliged. My lord, the respondent has also filed contempt, my lord. It is contempt 806 of 24, my lord.
Today listed.
No notice has been ordered yet, my lord.
Today
It's not
listed.
come before.
Listed. When it is contempt.
No date is given, my lord,
Contempt petition number 806
of 24.
or 24 shall be listed along with the present up.
Obliged.
13 is urgent. Number 14, Mr. Shrikant MP.
Delay is there.
Delay is delay of
Lordship, similar writ petition number, writ appeal number 271 of 2025. Yesterday came before this honorable court. The Lordship, next date of hearing, that is 17/4/2025.
notice dated on 17/4/25.
Connected this matter also.
We connected with rate of number
271 of
appeal. Yes, next. 15 or also delay.
Commercial appeal, number 15, Mr. Abhinav Ramanand.
I appear for the appellant, my lord. Matter, my lord, arises, my lord, by refusal to grant, my lord, an interim order. There's a delay, my lord.
There is a delay.
I'll serve the, my lord, respondents.
But anybody is appearing for the other side. Please let the notice go returnable on 7th April.
Yes, my lord. I may also be permitted to, my lord, serve the notice by hand also, my lord, in addition to the usual.
Number 16,
Appear for the
the
appellant
arbitration matter.
in this matter. Look, this is a section 37 appeal challenging, my lord, an order under 34, rejecting, my lord,
37P.
37, section 37 of the Arbitration Act, an appeal under section 37, challenging, my lord, the order of the civil court, rejecting my petition under section 34.
It's an appeal under 37.
37, yes, yes.
That's right, that we have. Yeah. Yes.
My lord, this arbitration claim was for specific performance of a contract for transfer of about 27 acres of land, and, my lord, a claim for damages
1 second. Arbitration claim was
for specific performance with respect to an agreement to sell and a claim for damages. Lord, we had pointed out really 5 important issues under section 34 because Lord,
One of these is limitation.
one issue is limitation.
That somewhere you are pleading that.
Yes, Lord. This is exhaustively argued and our contention, Lord, we didn't ask the court to examine. We pointed out that the learned arbitrator, my Lord, had erred completely in applying law. Time is fixed for performance of a contract. The first part of Article 54 applies of the limit, and it is 3 years from that date, unless there is an extension of the contract by a contract in writing. And that, my Lord, is, in my humble submission, the settled legal position insofar as this is concerned. And Supreme Court, my Lord, had specific, and we cited a judgment directly on this issue, that conduct of parties will not extend the time frame. And that, my Lord, in my humble submission, was a direct judgment of the Supreme Court on that point. That, my Lord, was completely ignored by the learned arbitrator, and the finding was exactly opposite. That the conduct of the parties results in extension of time. And when we pointed it out, my Lord, to the court below, the learned civil court does not even advert to the contention, does not even answer it. My Lord, kindly look at the award straight away. I'll show you, Lord, one paragraph, and I want to show you, Lord, one judgment directly on this point. Page 513, my Lord, at para 383. I'm sorry, my Lord. Page 467. I'm so sorry, 467. Page 327. I'm sorry, para 327, my Lord, at page 467. This is Arun, page 467, my Lord. The aforesaid makes it clear that when a statute refers to the word, it should mean having final or crystallized form or having character not subject to any change or fluctuation, which is not in the present case and as much as observed earlier, when after the date was fixed. Therefore, by conduct of the parties, the date mentioned in the contract was done away.
It was what kind of purpose?
Sale of property. The contract, my Lord, was entered into on 2/11/2011.
So by conduct, you can't extend the.
No. When a date is fixed for performance, then, my Lord, conduct does not extend time. But where a date is not fixed for performance, it is the date of refusal to perform, which is the date for giving a cause of action to sue. When a date is fixed for performance, at least 3 judgments of the Supreme Court, my Lord, says the date is the crucial date for cause of action to start, and limitation starts from that date. However, extension, Lord, can only be by an agreement entered into between the parties to extend the time, and not by conduct of the parties. And that exact issue was argued before the Supreme Court and answered, which was in Urvashi Agarwal. In the very next paragraph, we cited that judgment. Learned arbitrator holds that, and holds, my Lord, that that does not apply on facts. But I'll show your Lordship, not exactly the same situation.
Here is the plan. We have to hear it and learn. We'll fix up with it.
Yes, my lord, but let them not take any precipitative steps in the meantime.
Ever asked for even before the court under section
That is all
34.
right, but then when we are seized with the matter, you don't
But I am ready.
record the state,
I beg your pardon, my lord?
record the state.
Yes.
Statement as to.
No precipitated.
Lords, I have not filed any execution as on today. I will not file an execution. A date may be.
Lordship
fixed, I
may
will
record
be-
his statement then, Lord, that they will not execute it.
I will not execute it. They let there be no stay. I have to only secure a sale deed from a civil court now by filing an execution petition. We will not do it, but let a date be fixed. Lords,
Yes, my
contract of 2011, I have paid around 60 crores of rupees for this property. We have waited for all these years. There is a specific finding of fact. One fact I would like to bring to the fore. Limitation is always a question of fact. They did not enter the witness box to demonstrate any document. Their allegation relating to limitation was, I have refused performance. On the face of my refusal to performance, you did not file a suit in time or make an arbitration claim. Document was not proved, they didn't enter. There were 3 vendors under my agreement. There was a difference of opinion. There is an internal communication between my vendors that they will not perform. That is not brought to my notice. I am not aware of it. They don't enter the witness box. May I request paragraph number 382, my lords of the award, which is at running page number 512. Just to
Yeah, I'll
impress.
point out, there are 2 issues here. We pointed out, one is a date fixed in the agreement, and the second is, even if you don't assume that not to be correct, then there is refusal of performance. So my learned friend can't jump the gun and say, I did not take up the contention.
Learned friend can have his say, I will reply thereafter.
Yes, I'll argue.
My learned friend insisted on an interim order, I am only submitting. There was never an interim order granted by the court. In fact, knowing they have to deposit in excess of 40 crores of rupees, they never sought for an interim order at the hands of the learned trial court.
Why there are 2 arbitration petitions?
No, the second arbitration petition was filed by other 2
2 parties.
other parties.
I'm appearing for the other 2 parties.
Is
A fellow vendor with
There,
Tripartite
I'll
it was
give
a agreement, my lord, where there were 3 vendors and 1 purchaser. The other 2 vendors now want to say or disclaim any obligation on their part and say, we are not responsible.
This is only one appeal is filed.
only one.
One appeal is filed.
We have not preferred any
Lords,
appeal.
there were
This
3
is
vendors,
referable to arbitration petition 78.
No, my lord, 49.
49. There were
78
3
I had
vendors.
filed.
There was a single award in my favor against all the 3 vendors. All the 3 vendors filed appeals under section 34. Except 2 people took, one appeal is appeal number 78 and my learned friend filed 49. Now further appeal is filed only by the petitioner in AP 49 before this court. The second submission I would like to make. There is a monetary award also which is passed. Would be extremely unfair in a situation like this to say that the blanket stay may be granted. I would only make the submission. We are ready. We have argued as of 1.5 months ago. I am ready even as of today. I can take the court in 15 minutes relating to the facts of the matter and conclude. If my learned friend is ready today, I am ready today.
I am ready. Always ready.
Secondly, my lords, I would like to make one submission. Lords, one additional submission I would like to make. Insofar as date which was fixed for performance, the first date of payment of the advance sale consideration of around 60 crores was paid after the date fixed for performance was agreed upon. On the 30th of January 2012, they had to execute a sale deed. There was a litigation relating to the property, the advance performance. So the arbitrator found that there was no date fixed after that payment at all. That date had already lapsed when I made the first payment pursuant to the agreement. The payment was in escrow. May I only request paragraph number 382, my lords, to that extent we looked into.
Lord, I think
Page number
I should start anyway. So, and the point, Lord, is really the claim, Lord, was A, The award is B, in the sense, what is not claimed is awarded. Whatever was claimed was rejected. And the Honorable Arbitrator, my lord, went on an analysis completely different from the claim that is made and made an award. We don't have notice of all those things. And the arbitrator says, I'm doing substantial justice between the parties. A concept, my lord, which is unknown in arbitration law. I'll be able to show, my lord, as to how the claims, my lord, are completely different. The award is completely different. And has absolutely no connection whatsoever to the claims.
This is a lot of record is.
Yes, my lord. It is.
Look at the award.
The size of the award is long, my lord, but I'll be able to pin down, my lord, a few issues. No, not deter.
Deter, we are not deterring. We are on the contrary attracting to hear it at length. We are attracted to hear at length because of the lengthy rate.
Lord, we
would have deterred only if it is a 2-page award.
Lord, I won't take too long in this matter, my lord. There are 5 issues which I'll specifically point out, which are issues under 34.
Happen that the lawyers deter from arguing, but not the court deter from hearing.
He said it should not deter the court.
7 of the Arbitration and Conciliation Act. And an order dated 16th January 2025. Passed by learned first additional civil sessions judge at Bangalore. Insofar in arbitration, a petition number 49 of 2022. It was sought to be highlighted by learned advocate Sudanchin appearing for the appellant. That the arbitration claim was in relation to the specific performance of the contract, which was land. The agreement to sell was entered
by
three
vendors and 1 purchaser.
The paragraph, the award of the arbitrator,
page 175.
Found on record, runs into voluminous pages. To the operative part. To decide the mutual rights and obligations of the parties as per the award given. Full stop. Learned senior advocate for the appellant would submit that important questions of law arise. Learned senior advocate for the appellant took the court to the basic facts and the relevant part of the awards to submit inter alia that important questions of facts and law are required to be adjudicated, including the aspect of limitation and the applicability of Article 54 of the Limitation Act. It was submitted that the time to perform the contract would not be extendable unless there is an extension of contract in writing. However, it was sought to be argued that, the arbitrator has held that the time stood extended by virtue of conduct of the parties. Full stop. It was submitted. This is one of the moot aspect considerations to be gone into. Full stop. On the other hand, learned senior advocate, Mr. So-and-so, so-and-so, and so-and-so, so-and-so, who appears on caveat, sought to justify the So to prima facie justify the arbitral award and the dismissal of the petition by the city civil court against the said award. Full stop. The court finds that the appeal this petition, it is a the appeal requires a final the parties agreed that it may be taken up at a convenient date.
Yes.
Finally, the paragraph. Since the court is since this court is seized with the appeal to examine the judgment and order of the court below with reference in the context of the arbitral award, the findings thereof, from the court was inclined to pass interim order. However, it was stated by learned advocate both of the learned respondents that
are one.
Respondent
number
one.
man. Successful. They are the claimants, we are the respondents.
The other respondents don't have a decree to execute. They are with me actually. They should be on this side.
that the respondents shall not file any execution petition. Please, shall not take any precipitate action. In that view, recording the statement, the appeal is directed to the listed. Next one, which date?
That's 22nd of March, a Saturday, working day.
Oh, it that early time for the court. 22nd, we have come some other matter list. It can be only in April somewhere. 22nd April is yes.
No.
That's last. Too late.
First week of April, my lord.
First week of April.
Too difficult.
First to second week at 2:30, my lord. I will not take more than 1 hour, my lord, in this matter. 1.5 hours the most. Because I've identified the specific issues and I'll show your lordships how the award can be sustained.
Only thing that we have to just sail through the facts and law.
Yes, my lord. That is true.
We'll
but-
prepare a synopsis.
We are deterred only in that.
No, my lord, it's, though the award is long, I think your lordships will be able to identify, my lord, the specific issues because I'm not going to take your lordships to the evidence or anything of that kind. I will show you lordships how on law it can be sustained.
7, 8 or 9.
Yes, my lord.
7th of April.
7th.
7.
7th at 2:30, my lord. At 2:30, lordships can have it.
You just request, depending upon what board is, how is the situation of the board.
Yes,
Any other. We'll try to take up as early as possible.
I'm very great.
Great.
Monday. Monday. Yeah.
This number 17, Adi Narayanappa.
Yes.
Hardships were of the view that the agreement entered by the municipality with me is not in accordance with law. And I have, basing on that agreement, I have invested around 4 to 5 lakhs. Hardships is relating to the pay and use silently. 4 to 5 lakhs I have spent.
We had a,
You
was enjoyed 20 years of that.
I am paying the license fee to the municipality. It is not that as a good gesture for having renovated it, they have given it for me. The thing is, they
Sir,
should have called for a tender. I completely.
There are two issues which arises over here.
Totally.
First thing is
But the thing
whether any tender was called before entrusting the work to you.
No, man, no,
Now, if the answer is no, then is it valid in accordance, according to law?
Lord, at least before calling for new tender, at least a notice to me. I am an agreement holder.
At least a notice to me, that has not been done. That is the reason learned single judge granted me time to operate this pay and use toilet till December 2025. 2021, please, my lords, I have renovated. Limitation will also be. Lordship may kindly see the operative portion of the order. To balance the equities, the learned single judge just passed. Operative portion of the order, annexure A. But if a limited, this thing, please, my lords, very limited this thing, order. Tender is issued.
My lord.
Tender is issued and awarded to you.
Yes, my lord.
When it was awarded?
The tender was called for, my lord.
Tender is awarded to you as on date.
Yes, yes. I am
on-
being in a highest bidder in the,
On which date it was awarded?
it was made on
Publication 6/3/2020.
6/3 to the, I have filed the application along with the document.
6/3.
Uh,
6/3/2020.
Page 71, in page 71.
Give the date, 6/3/2020. Three. For how many, what is the period of tender? Tender contract? For me, my agreement was on 13/9/2021. After 2 years, they have called for a tender. They allowed me to opt. In your favor, tender is awarded
Yes, yes.
on 6/3/20.
21, 6/3, 23.
23. For what is the period of contract?
Contract for 12 years.
12 years.
12 years.
12 years.
12 years.
Annexure. But then why that should be posted? Annexure A. 12 years. Page 36. Annexure A, page 36.
Without hearing this. And call for tender and they choose. Call for tender. Oh. The balance of the equities, this judgment is passed. The mischief is played by the city municipal council. The city municipal council will be fine. No, they're not taking any stand. They just left it at that. So who from the created by the city municipal council? Who appears for city municipal council?
Council is not here.
It is they who have played all the mischief.
They have played all. And in my agreement, they say you spend.
Initially, they are leased out.
Spend your money, renovate it. We will give you this thing. You pay the license fee. There is no loss to this thing. I am paying license fee. DDs, copies, bank statements I have produced. And this appeal is by you.
Yes, ma'am.
His agreement is quashed. Subsequent agreement is quashed. Petition was by you. Petition is by me. Against the agreement which has been entered by the municipality. And municipality makes a wrong submission before the court. That still it is operating it. But however, it has handed over to the appellant now. His agreement itself is quashed. He is operating it now. I am the loser now, please, my lords. I am the loser here.
After his term was over in 25 December. If we reverse this. Initially, it was given to him for 20 years. After completion of that period, tender was called for. Okay. We say that after that is not
Council for town municipal council.
So
Initially-
now, today the order is against you, to the extent that the council's, the original petition is permitted to maintain this facility up to December 31. Now thereafter, your contract will come into force. You have got 11 years.
Yeah. for their own submission. The mischief is played by the city municipal council who is not here. Okay. This is an equitable order.
Yes, my lord.
The only grievance that you can have is that allotment in your favor is quashed. Okay. So we propose to balance out equities only.
Yes, sir.
Let him continue till December 31st, 2025. Anyway, he is not in an appeal.
Yes.
He has accepted this order. This order gives him a right to operate the premises till December 31st, 2025. Thereafter, you take over and you operate for the rest of your contractual period.
Okay.
Are you agreeable?
Yes, yes, my lord.
Huh?
No problem.
You are agreeable.
Yes, my lord.
File a joint memo, both of you.
Yes,
File a
yes.
joint memo.
He has to come, my party needs to come from Tarikere, Ajampura.
Yes, you are not losing anything.
From last 25 years, he enjoyed
You are
the
in joint.
premises.
In Ajampura bus stand, there was no public toilet. 20 years.
Sir, all those are, we don't want, sir.
I am not on that. I am not. You will file a joint memo. Joint memo, you are not losing anything.
You're not losing anything. You're not losing anything.
I will ask my
And you are
client
succeeding.
And you're succeeding. Only thing is,
for a limited period.
instead of
From the date of that period should be expired.
what period, sir?
Single judge's order.
No, sir.
We are in March.
No, sir. You have accepted the order passed by the Leonard single judge, sir. Don't, and you are not preferred an appeal.
He is operating it now. He is operating it now.
It will change hands next week. Nah.
Please, Malik. Please. Lordship may have this on Tuesday. But
See, otherwise, if we go strictly,
you know the situation where I stand.
and then,
You are also have this on.
because after looking into the papers, we realized it.
I fully agree with you, Lord. Tuesday, your Lordship may have this. You will get the.
Yes, next week.
Coming Tuesday.
Yes, ma'am.
The municipality doesn't, after all, at the end of the day, he is your officer. Get some instructions.
I'll take some instructions.
Ask them to come and sign over here.
Very well, my lord. They were represented by counsel before the single judge. I will inform them. We'll ask them to come. There's a panel counsel, my lord, who has appeared before the single judge.
Whatever, communicate to the officer and tell them the court may come down heavily on that person.
Very well, my lord. I'll communicate. Before
It has
Tuesday.
been a highly irresponsible act on behalf of the council, which put both of them under trouble.
Understood.
So it will be a consent order from all the three parties concerned and things will be resolved.
Very well, my lord. Lord, and make one more submission, lord. They were represented by a counsel. If they can serve a copy on heralds, I will certainly I will do that. I will ask the officers. to-
See, your executive officer is government servant, right?
Correct, correct. I will do that, my lord.
Do it.
11th or 12th?
11th.
11th. 10 or to 11. We'll post it at 2:30. 2:30. Great.
Number 18 is urgent. Still number 19, state appeal.
And for the respondent,
Yes.
file objection for the delay of 381 days. Yesterday only.
Learned advocate, Ms. so-and-so wants to file objections to the delay of condonation application. When shall we keep? Tell your date.
Next week, anytime. Next week, well.
Next week, to be listed on 20th March.
2021 are.
For respond. Applicant in this case.
Applicant.
I've not been served any application. My lord. The petition, my lord, pertains to the rehabilitation of 25 families. My lord, may please see the orders. This honorable court, my lord, has passed 3 orders in regard to this. And on 31/1/2022, the state has filed a compliance affidavit as well, my lord. The most recent order, my lord, may please see 9/7/2021.
Page?
My lord, the order dated 9/7/2021. 2021, please. Yes, my lord, certain lands were allocated for rehabilitation of these families. So in regard to that, it was called for by this honorable court on 9/7/2021.
Yes.
If I could please read paragraph 4 and 5, my lord, it's of this order.
Read it.
Please. It is stated that this is the affidavit of Shri N. So-and-so, son of so-and-so, Principal Secretary of the Government Revenue Department. Paragraph 4. It is stated that the proposal of the 10th respondent for undertaking the rehabilitation of the evicted persons is not feasible, and therefore a proposal shall be submitted to the cabinet for retransferring the area of 2 acres 10 guntas in survey number 110 to the state government. And once such a decision is taken, necessary orders shall be issued under section 71 of the Act, reserving the said area for Ashria scheme.
Now,
and
these persons are evicted for what?
for
reason?
2014, my lord.
Why?
They were, my lord, it was a slum that was on forest land.
They're also for petition.
I am only for the petitioner, my lord.
I'm pleading it.
Yes.
So why they were evicted?
My lord, it was a slum that existed for around 30 years. Forest department said that this is our land, my lord, and overnight they were evicted. The state then, my lord, took a decision that because they were evicted in such fashion, we should rehabilitate them. The honorable court considered all the papers and that a decision has already been made to rehabilitate them. Let it be done expeditiously. Hence, this order was passed. On the subsequent to this order, my lord, a compliance affidavit is filed on 31/1/2022. 31st January 2022 by Shri Manjunath.
Can you,
31st January 2022.
My lord, it's filed on 1st February 2022.
First February, yes.
Yes, para 3 may please be seen, my lord. There was a cabinet decision proposal that was referred to in the order dated 9/7. Please read para 3, please, my lord.
Yes, which page you are showing?
Para 3, my lord, please. In terms of the directions issued by this honorable court, the Principal Secretary to Government Revenue Department has also filed his compliance affidavit, and the state has also filed a memo of compliance dated 13/9/2021. Pursuant to the filing of the statement of objections, this honorable court directed the state government to allot suitable land and also to expedite allotment of said sites to the evicted persons of Gotigare Village, Weavers Colony. In terms of the said direction, a request came to be placed before the cabinet, and on the approval of the cabinet, land in survey number 110 of Koppa Village, Jigni Hubli, Anekal Taluk, measuring 2 acres, 10 guntas, was ordered for earmarking of formation of sites and also allotment of sites to the evicted residents of Gottigere Village, Weavers Colony. Thereafter, the state government issued government order dated 9/9/2021 and directed the deputy commissioner to physically transfer the subject land to the executive officer for the purpose of formation of sites under Ashraya scheme within a period of 1 month. Para 4, my lord, please. Because 10 guntas of land village to the executive officer. The land transferred produced and marked for kind of of this honorable court. There are the deputy commissioner direction to the executive officer annex and also allotment of sites for rehabilitation of the evicted residents of Gottigere Village, Weavers Colony. Under these circumstances, compliance and respect of transferring the land for forming state that the executive in matter to complete the process of formation of sites and also allotment of the evicted residents of Gottigere Village, Weavers Colony. So please, my lord, this matter, we stand at this stage, my lord.
You stand satisfied.
Please, my lord, but if a time frame can be given, my lord, that's all.
We taken to logical end.
Yes, my lord, that's all that's required, my lord.
Yes.
The survey 1110, the land is mine, your lord. That's why I'm impleading, I'm impleading kind of the case.
Which land is yours?
Survey number 1110, now it is 1110/10P, 4 acre 11 guntas. I have stated in my impeding application, your lord. 31/1937, your lord.
We are closing this year. Land is approved by the cabinet.
My lord, it's approved. My lord, it's approved. Now at the last minute, if he comes and claims ownership, I don't understand this. There must have been further developments also with the marking of the sites and people occupying it also. Coming in a petition and then saying the land belongs to him.
No, but you need to verify and state whether the land belongs to him or it's government land where government can allot it
Then
to
again,
slum dwellers.
Then my lord may grant me some time. I'll have to redo the entire, my lord, seek instructions, redo the entire.
When he files an interlocutory application, you are required to look into it.
But for me, produce the photostat copy of MR stands in my name presently, your lord. And ACR
He is relying upon mutation entries, which are government documents.
My lord, let him provide me a copy, my lord, I'll do it.
By virtue of the Honorable High Court of Karnataka order. It is in reserve forest. Forest department has evicted.
The original places were.
They were occupying the
Originally,
forest land, my lord, and now by virtue of the orders
It's
of the.
reserve forest.
What you are producing?
Which reserve forest?
They were evicted from reserve forest.
No, which reserve forest? What is the name of the reserve?
Yes.
This is
Name of the reserve forest.
Yes, sir. Earlier, this slum was
Name of the reserve forest.
Gottigere Graph.
Banegarh.
Banagat reserve.
My lord, survey number 109 of
Next year, penal.
Gottigere village.
That.
Banegarh Vanyajeevi Valaya.
37. I'm granted.
Should kindly see Annexure B.
Proceedings under section 64A had been initiated.
Yes.
And 125 families have been evicted. Now they are sought to be. And now they are sought.
Granted, this is 1937, it is granted land in the name of Muniyamma, Mayer. Granted.
What is the position?
I will, my lord. But I don't know where he was when proceedings under section 64A of the Karnataka Forest Act had been initiated.
Which has been subsequently allotted to.
That is part of the forest land, my lord, for which proceedings had been initiated, and then it was de-reserved again from the forest land. If he was in possession, he would have been aware of the proceedings.
No, I approached the AC has confirmed, and accordingly mutation has been.
You verify and make a submission. You provide all the documents.
I'll provide.
When we'll find out. First April,
My lord,
1st April.
my lord, third or fourth, third or fourth.
Third.
Because the assembly is in session, my lord, I won't get any instructions till the 20th. Obliged, my lord.
Grateful.
Number 23, Mr. Subramania Bhattayam.
Understanding is to the effect that the matter has to be heard, and the question involved is the validity of annexure H, the act number passed by the government of Karnataka, which nullifies the judgment passed by this honorable court in a division bench and confirmed by the honorable Supreme Court. That's a no. The is also fortunately.
Legislation is a piece of validating legislation, my lords, where the basis, my lords, of the earlier order pass. Point number 2 and 3, my lords, that was on the facts of the case, my lords, it has been implemented. Now, my lords, on 11/8/2021, this honorable court by order dated has referred to the decision in 2010 9 SCC 655 with regard to maintainability, my lords, that he has to overcome.
No.
Otherwise, my lords, if my lords feel that in service matters, this matter could be.
No, with respect. Friend, this particular point has been considered. I can give the para numbers 222 to 252. The division bench of this honorable court has considered and said that the public interest litigation is maintained. And in spite of it, my learned friend wants, I have no issue. I can straight away read those paragraphs.
But then it can be posted for hearing. It is challenging the provisions of the act. In a PIL, notes, we are ready, notes. Could fix a date, notes. Earlier round of litigation, it was by the non-selected candidates. Thereafter, my lords, this honorable court, my lords, gave its verdicts on 3 points. Point number 1, my lords, we have removed the basis, and my lords, this validating legislation has come about. But ultimately, my lords, it is about appointment to the services, to the civil post in the state. The act itself is about the procedure to be followed for the appointment to the civil post in the state, gazetted probationers, my lords, and other posts. So, per se, it's a service matter, but in view of the fact that earlier PIL was entertained and question was answered, my lords, maybe we will say it could be posted for hearing itself, my lords. But apart from that, it has to be heard.
That's true.
This court has said that it is maintainable.
No, my lord. This court,
true, my lord. This court had given a clear finding.
In the earlier round.
It is maintained.
In interim order.
No.
This
In a
court has
final
kept-
order in the earlier round of litigation,
But in this, in the order sheet, my lords, 11/8/2021, that question has been posed to them to first convince on the maintainability.
Incident.
That has not been done still. So therefore, including maintainability, it could be posted for hearing, my lords, once and for all.
Any order is there in that regard?
11/8/2021.
Well, I can straight away pray my lords.
Sir,
Paragraph
I'm-
number 222 to 254 in Annexure B. Point for consideration was raised. It was answered. And it was confirmed by the Honorable Supreme Court in 2 occasions. Then an attempt was made by way of a review cum clarification. That application came to be rejected with the cost of rupees 1 lakh. Probably my learned friend was there on the other side in a different capacity then.
It is there, order is there, in light of the judgment of the Supreme Court in Haribansla. Learned counsel preparing the petitions address the arguments on the maintainability.
That's all. After that order, till date, it has not been addressed.
So we start with that whenever we fix.
Please, my lords. We'll get it.
And Mr.
But I can start right now, my lords. I'm ready with the matter. I can.
We are
present
also-
it.
It is about balloting. Or my lords may fix a date also.
To fix it,
Fix it,
somewhere in April,
please.
9th April.
9th.
9th.
You put it with this judgment.
This is number 24,
Grateful.
the Ganpati Bhatt.
My lord, senior as an inconvenience. 1 week time may be granted.
4 weeks.
1 week.
1 week newly granted 4 weeks. 25th of April.
Number 25.
This matter was heard for some time and government advocate was requested to file objections and seek instructions.
Of the government that is under challenge before my lord. My lord, the petitioner has taken a contention, my lord, that that an order has been passed in respect of, my lord, a question which was not, my lord, posed to him in the sense, Rule 3G. My lord, he's taken by surprise with regard to a finding on Rule 3G of the Karnataka Mines and Mineral Concessions Rules. And my lord, one of the reasons that he finds as a lacuna in this order is that no opportunity of hearing had been given. My lord, could I seek for 2 weeks' time, my lord, to get instructions from the secretary, my lord, because what I find is, my lord, he's got confused with regard to 2 survey numbers. So if I could make my submission after 2 weeks.
But take instructions. 21st April.
My lord, the session gets over, my lord, any date, 26th or 27th, my lord.
Of March.
March.
27th.
Obliged.
27th.
Much obliged.
28 are agents. Number 29, Mr. Satish K.
Short accommodation, my lords.
Contempt petition, you can argue.
My lords, senior has to argue in the matter, my lords, short accommodation.
You grant, what is the order? Tell us. Which order is under contempt? Not having the papers.
Final order dated 18/7/2023 in writ petition number 4808 of 2020. My lords,
Page,
short accommodation, my lords, next,
will
in
grant.
the next occasion, I'll argue the matter. Next occasion, senior will appear, my lords.
18th July. Will grant time, don't worry. 18th July is the order.
Plus short accommodation.
Will
my
grant
lords.
time. Let us understand. 18th July is the order.
My lords, not aware.
So it is complied with or not? This is already reinstated. Within the period of 15 days.
My lords, the order is not complied and I filed rejoinder for the same. My lords, one accommodation, next occasion, senior will appear.
When shall we take your date? Whichever date you want. Whichever date you want.
Any date, my lords.
No, you have to tell the date.
24th.
24th.
Hmm.
24th.
Grateful, my lords.
This is number 30, Mr. Ajit Kalyan.
Appearing for the accused, your lordship.
Complied with. Learned advocate, Mr. So and so for the petitioner. The addendum where learned advocate will respondent by filing memo. Dated, undated memo. Stated that the present petitioner is considered an endorsement dated 5/3/25 past, thereby complying with the directions of London Single Judge, post of copy of the produced in vernacular, which was explained to the board. In the above view, nothing survives in the contempt proceedings. It is disposed of accordingly.
No silent.
Number 31. Mr. Keshav Murthy B. Number 31. Mr. Keshav Murthy.
Nobody is there, let it go to 22nd April.
So 32 is urgent. Number 33. Manjunath.
There is positive direction, my lord, to restore the names of the complaint in the revenue record immediately, my lord. This is the order passed on 19th September 2024. Till today, my lord, even though issuing the notice, my lord, they have not restored my name. This is second time after service, my lord.
Lords, my instructions, my lords, is in the process, my lords. My lords, if some time is granted, it will be complied, my lords.
No, my lord, kindly see the my lord. This is second time. This is unnecessarily taken time, my lord. This is
I'll
second, last occasion also directed.
I'll file an affidavit to the effect in 2 days. If that is the case.
Clear direction, my lord. Kindly see, my lord. Learned single judge, my lord. He wanted to say, take serious action against the particular accused, my lord. He is observed in the order, my lord. On the basis of the undertaken by the significant details clearly affect that the conduct of the respondent 4, the Tahsildar, and also indicated there is a clear dereliction of duty on the part of the respondent 4, Tahsildar. Though this is a fit case to instate the action against the respondent 4, Tahsildar, having regard to the fact that the AGA is assured that this court that the petitioners in the court proceed to pass the following argument. They undertake, my lord. They undertake to restore my name. Till today, my lord, more than 4 months.
When you comply.
I'll file affidavit in 2 days. Monday, I'll file my affidavit, my lords, that about the compliance, my lords. I only
Monday.
may make one submission, my lords. In this case, my lords, the Tahsildar has made all his efforts to restore
the Kata in the name of the complainant, my lords. There was an 136 proceedings pending before the Assistant Commissioner, my lords. That has been also been getting cleared, my lords. That's the reason I said in 2 days I'll file my affidavit in which date the complaints will be done, my lord. That was my humble submission, my lords.
Maybe day after tomorrow, Monday.
And they will filing.
Tuesday, my lords.
Tuesday will filing affidavit.
Please, my lords. Tuesday I'll file my affidavit, my lords.
Will filing affidavit on that day.
Tuesday, my lords.
Tuesday will be filing affidavit.
Please, my lords.
Learned additional government advocate wants the time up to Tuesday to file the affidavit. Response to contempt petition. Send over to seventeenth March. Before 11th of March, reply. They will file.
I'll file it.
If any.
Please, oblige.
Cell number 34, Jagdish Shastri.
Number 2 in this matter. Compliance is ready.
Not, they're taken back, Miller Robert. Taken back, they're taken. Moreover, liberty may be guaranteed.
Some order was passed by us or not. This is not that.
Taken back.
21st February 2024, my lord, annexure
Single
A.
judge by
Not-
single judge by judgment and order. Passed from 21 to 24. Inter-alia. While allowing the repetition in part from directed the respondents to continue the services of the petitioners as teachers or lecturers till regular recruitment is conducted. In accordance with the Karnataka Residential Educational Institutions Society, the cadre and recruitment rector and regulations 21. The necessary directions having already been issued. We are
I am appearing for the
Reinstated.
respondent number 2.
reinstated.
Please, my lord.
Necessary directions are issued to reinstate the petitioner, which factum is not disputed well on the petitioner. Petition stands reinstated. That's all.
Liberty may be given.
The contempt petition does not say what liberty.
If it is not, once again they disturb me. If once again they disturb me,
There is not survive. Dispose of learned advocate for the petitioner submitted that liberty may be reserved. If the petitioner were to terminate it, to press cause of action to the petitioner to seek relief, if any, in accordance with
serial number 46 similar. 46, serial number 46 is similar.
46 is similar. Same order.
46, we have not filed wakalat, my lord.
But the government is there.
We are also a respondent number 2 in the 46.
Similar means what?
Same is, same institute, same issue, same relief.
Same order.
Same order, my lord.
Same order.
Notice ಆಗಿದೆ.
Mention the appearance.
My
of
lord, I may undertake to appear on behalf of the
In 46.
46.
Learned advocate Mr. So-and-so appears in 46. 46
46 serial.
appears and must file Wakalatnama while disposing of.
46.
Wakalatnama full stop. Operation shall accept the Wakalatnama if filed within 1 week.
So already, as per their instruction, my lord, it's already
Taken the.
Reinstate.
Reinstate.
Obligor.
Case number 35, Mr. Janardhan G.
Pay for a time to file my reply, my sir.
Appearing for complainant, my lordship.
Pay for a time to file my reply. I pray for time to file my reply.
My lordship, they are continuously violating the order, my lordship. A short
Okay.
date may be fixed. Earlier also I have initiated contempt proceedings, my lordship.
He wants time 25th.
Six is urgent, case number 37, Mr. Abhinav Ramanand. 37.
File my statement of objections.
Right, okay, good.
Request some time.
Before other bills. Number 38, Rajit Kalyan.
They are filed and compliance affidavit. I'll take necessary instructions.
28th of March.
Obligations.
Number 39, Mr. Vinod Kumar. 39. Vinod Kumar.
Right, of April.
Number 40, Mr. Shailesh.
Waiting for the complaint, my lord. They have not filed the reply, my lord. They have not filed the reply, my lord. Reply, please. They have to reinstate the complaint.
What is the direction? Let us see.
Sorry, my lord.
What are the direction?
My lord, kindly see the page number 21, my lord.
Read it.
Para 23, my lord.
23, yes. In this petition.
In this petition, an affidavit was filed in support of his affidavit. He has also filed the consent letter of his elder brother Ishwar. In light of the facts of the elder brother Ishwar is agreeable to forego his appointment, it could be appropriate to dismiss the writ petition and direct the Konkan Railway to continue Ravindra as a gunman, my lord. They filed the writ appeal, my lord. Writ appeal also dismissed, my lord. Till today, not taken the complaint as a gunman, my lord.
So what is the direction? Where is the direction? Where is the positive direction?
That allow the writ petition filed by the Ravindra and direct the Konkan Railway to continue Ravindra as a gunman, my lord. They dismissed the service, my lord.
You not continue.
Till today, not taken, my lord. They filed the writ appeal and writ appeal also dismissed, my lord. On 19/3/2024.
Which was Konkan Railway?
Please.
Who wish to comply?
Omkar Kambi, my lord. Last time they will
Konkan Railway.
For advocate.
Who appeared?
Omkar
Kambi. Omkar Kambi. Last time they had taken undertaken for Waka to
22nd.
Number 41, Mr. Nagarajan. Number 41, Mr. Nagaraj.
22nd April.
So 42 is urgent. Number 43, Mr. Dhruv M.
Here for the accused, we have complied with the order of the learned single judge, my lord.
One second. Lifestyle ನಡೀತದೆ. ಈಗ next ಬರ್ತಾ ಇದೆ.
Yes, who-
My lord, the single judge, my lord, had asked us to dispose of an application filed by the complainants, my lord, which, my lord, we have disposed it of, my lord, by giving him an endorsement on 13th of February 2025. my lord. But that endorsement is also been challenged by the complainant.
It's not challenged.
Correct. Complaint, which contempt is over.
Your lordships, this is the endorsement. One page, this also the endorsement. Lordships, I'll take your lordships straight to paragraph number 2. The said request has been examined in DGCA in terms of the available regulatory provisions governing such subject related to approval / renewal of the microlight aircraft examination. On examination of the said request, it is found that currently there are no established guidelines or frameworks in place under which such approval / renewal could be considered. As such, the request of Agni Aero Sports Adventures Private Limited, communication dated 2/3/2021 and 24/5/2021, requesting for consideration of application examinership cannot be acceded to. Now, what is it that they say? Do they accept my application or do they reject my application? They say, I do not know what to do with the application. They say there is no law.
Rejected.
To reject my application, they do not accept my
That is
application.
rejection of your request.
No. In
Not
fact, your lordships, I'll
cannot-
take your lordships to paragraph, page number 10 of my contempt petition.
You produce this or by memo?
Yes, I'll file it today. In the counter, I'll file it.
In fact, last time they'd made the submission that there's no law. That's why we cannot proceed. Now, that cannot be an answer
Even-
to one niche. Paragraph number 10 of my contempt petition. Page number 10, Your Honor. Paragraph number 5. They say per contra, if reasonable time is given, the respondent, that is the other side counsel, he gave an undertaking to the court saying that I will take your application and I'll do what is required under law. Now that an undertaking to the court has some sanctity. Based on that, the court was pleased to, dispose it within upper limit, saying that as expeditiously as possible within 2024. Now, 2 weeks, Your Honor, it's not 2 decades, not 2 years, 2 weeks. Now, 2 weeks feels like eternity.
No. Give that. Endorsement is not coming from your side.
From my side only.
Like,
It's not from their side. But they were supposed to produce this.
you are filing something. Same.
There.
yes.
I produced.
It is already filed.
My lord, I produced this. I have sent-
Already produced
Yes, my lord.
today. huh?
The writ petition has nothing to do with this case.
So nothing survives.
Hello?
Nothing survives.
Nothing, it has nothing to do with this particular case.
Why?
There were 4 writ petitions. There were 4 writ petitions, Your Honor. There's one matter to deal with fuel. There's one matter to deal with examinership. There's one other matter to deal with the other license. This is to deal with examinership. All the other matters are dealing with some other subject matters. The writ petitions that he has produced deals with some other matters.
as far as I am concerned, I have voluntarily given an undertaking before the court that this will be done in 2 weeks, as per law. Now, Your Honor, two important considerations. One is, assuming there was no law, they have given it to hundreds of people. The same license is given to hundreds of people, but for my case, they make out a case that there's no law. Under what law did they give this examinership license to hundreds of people? Second, if they make the statement that there is no law, have they taken any action suspending or revoking or cancelling all the other licenses application? In fact, one more memo. This is produced as annexures in the writ petition. It's part of the writ petition. From 2021, Your Lordship, the accused asks me that, produce how many hours of flying have you done, produce this document, produce that document. 2021, the email correspondences that, as per section 7, produce this, as per section 8, produce this, as per this law, you produce this. Then on what basis have they asked me to produce so many documents, and I have complied with it? 2020 emails, Your Honor, page, I've just produced the page 2021 of that annexure. 21 is annexure E, Your Honor. Dear MK Sriram, request you to kindly send documents and flying hours in the same format as mentioned in CAR Section 7, Series 1, Part 3.1 of for Captain Arvind Sharma and Captain Omkar Uday. Now the next page, Your Honor, annexure F, page 22. I comply with it. I say, as per your request, I am sending the details. Then at page 23, these are the documents which are produced as per their requirements under Section 7, Series 1, Part 3, Part 3.1a, 3.1. Then next page, Your Honor, they say that, please produce that if there's any incident/accident-free records for the preceding 5 years. Now I produce the next page at page 25 and page 26. Page 26, to whomsoever it may concern. This is to confirm that this has not been involved in any accident. This is as per their template. Whatever they're seeking for, I have produced. Now they come up by saying that there's no law, so we do not know how to comply with the court's order. And the two other
Were you granted license earlier?
Yes. License was granted to me first in 1996. Then
where is that license?
It's part of the writ petition. I'll produce the soft copy. One copy. The other copy is given.
Now you are sought for renewal of the same license.
Yes. In fact, Your Honor will see the contempt petition annexure C, page 14. It's given to other applicants also. It's not a isolated strange case that, only I am seeking for this super fancy license. Annexure C of my contempt petition be seen. And in fact, page number 19 of my writ petition shows that,
Now I asked you, where is the earlier license that is granted?
Page 19 or page 18, Your Honor. I don't have another copy of this is the writ petition copy. MLP 1.
If you have granted a license earlier, that means.
Can I make a submission? My lord, a license was granted under the existing rules then. After which, my lord, after it expired for 5 years, he doesn't come for renewal. For 5 years, he doesn't come at all. Then he files an application. Then, my lord, that was not considered. Considered it was not disposed of. The writ petition is filed. The learned single judge of the Honorable Court to direct me to dispose of the application. My lord, after which, my lord, new enactment has come. The rules are still yet to be framed. Now, my lord, there's an interim wherein we do not know what exactly has to be done. That is how, my lord, this endorsement has been issued. And we have specifically said in our endorsement, my lord, that we have in compliance with this. And this particular endorsement is now a subject of challenge.
No, but if a license has to be granted now, under what provision
now,
of
my lord,
law
there
you
are
grant
only
it?
2 people in the entire country.
No, this is a wrong statement.
This is an
See,
examiner license, not a flying license, my lord.
Correct, examiner license.
Yes.
Earlier you granted him an examiner license.
Yes.
under
That examiner license got expired.
expired, yes,
Okay, he did not immediately apply for renewal of the same.
yes,
After a lapse of 5 years, he has asked for renewal of the same.
yes.
Now, it has to be considered.
We have said that we will consider, my lord, may kindly see the endorsement issued. What we say, my lord, is as of now, there are no existing bylaws by which we can be guided. He has to only wait because, my lord, I'm sorry, I'm not able to say the name of the exact enactment. Sorry, it was there. If the new, what is it?
He says the Aircraft Act does not exist. Aircraft Act 1937.
I'm sorry, my lord, there's a new
says
enactment.
There's no new enactment.
No, it is there. Why should I make a wrong submission and appearing for the, well, as per that, the rules are yet to be framed. Well, that also provides for, that will also be providing for examiners, pilots.
That rules are framed, the old rules are applicable, right?
No, my lord, no, that old rules are now, there is a vacuum. That is exactly what we have said. My lord, this has been challenged before learned single judge. My submission is only this. We have sought for time to file our objections. It has been adjourned for that. My lord, it is known as the Bharatiya Vayu Sanhita.
There's one more submission I want
There's
to
an
make.
enactment known as the Bharatiya Vayu Sanhita, which has now been enacted. Some rules are yet to be framed as far as microlight is concerned. This is regarding microlight examination. My lord, we have only said, we have only given endorsement. As of now, we are not in a position to renew your license. My lord, it is substantial compliance with order of the learned single judge, my lord.
And if I can make one submission.
And my lord, assuming, my lord, let us say this endorsement.
Presuming for a moment, Motor Vehicles Act is repealed. You say no license. What should happen to?
What happens?
What should happen to citizens, man?
My lord, unfortunately, this is a thing where not many people are there. Probably, my lord, motor vehicles would have created a big issue and they would have thought on this. It has
Whatever
not.
it is,
But my
whatever
lord, my
it is.
submission only would be this. My lord, assuming for a moment my endorsement might not be happily worded or not proper. Well, it's subject of a challenge for learned single judge. But I have complied with the order of the learned single judge, directing me to consider this application. We have said it's not acceded to, and we say it is in compliance with the order of the learned.
Do you mean to say similarly situated persons have not been granted?
My
Or
lord, what has happened, my lord, is that one particular lady was granted for lifetime, then under those rules, which probably
under
was
the
wrong.
present rules?
Not this, when he had applied in 1998 and all that. So that time, my lord, she was given. There are only two people, and that lady continues. My lord, we have issued a notice, or rather, we are in the process of saying that that process was wrong, but not as a trigger of because of this petition. But as far as this petitioner is concerned, well, as of now, my lord, it cannot be acceded to. Now there's a separate academy, sports flying academy, all that has now been done, my lord. Different kinds of academy, adventure sports academy, flying academy, micro rights. It cannot be put in the common, this thing, like how we cannot have the same reason, my lord, the new enactment has formed. The rules are yet to be phrased. We are still in infancy, my lord. That is why we said at present, we cannot consider your application under the rules which are existing.
What are the rules going to be framed?
My lord, it is, we are actually pressing for it to see that it's done as soon as possible. In fact, that was the oral submission which we had made before the Honorable Learned Single Judge in the GM court, my lord, last week. 2 weeks have been given to file our objections to that, which we will be doing, my lord. Now, as far as this contempt, my lord, with due respect, my lord, we have complied, saying that it cannot be given at this moment. Even assume it's not happily worded, my lord, we have complied with the order.
There are two judgments I would like to place before you.
See, the limitation is it's a contempt matter. You can't go on merits of the case over here.
No, not merits, Your Honor. Two submissions.
Fill the vacuum.
One is,
We will be doing it. In fact, my lord, we also have a pressurizing to do it. The DGCA my lord, will be filling the vacuum. We want to have on a wider spectrum, my lord. Because these are all, my lord, what happens is, generally, my lord, it is all the legacy of the British, where not many people do. Now, my lord, in fact, to even have a license, you must have a plane in front. So here, my lord, it's something for a person who will have his own flight, a small plane. He will be trained, he will fly it. So it's a completely different stream altogether. Like I can't go and say, train me if I don't have a flight, a plane. So that is how, my lord. So we are framing the rules in this regard, like air balloons, etc. My lord. Hitherto, my lord, everything came under the Aircraft Act. So now the new law has been enacted now. That is how, my lord.
Your Honor, two submissions.
We'll keep it 25th of April. If some development, let's see.
Your Honor, one submission, Your Honor. Just one submission. Let us forget about the new act, or whatever is in place, whatever submissions they have made. Let's assume, I don't know, the new act might be coming in place in 2025, or let's say in 2024. These applications were made in 2021 when the Aircraft Act was still in existence. Even if the letter we seen, it says without prejudice to the Aircraft Act, all the documents that they sought for was in accordance to that act at the point of filing application. The date given by the court was 28/6/2024. From then till the filing of contempt, nothing was done. After filing the contempt, if somebody complies with it, the contempt will still continue. My submission would be an NBW be issued to the accused and let the person answer it. Let the trial be conducted. Because this cannot go, I file a writ petition, then a contempt, it goes again, I file a writ petition. The courts cannot be powerless. Then nobody will want to come to the courts to seek for. I came to the court only because 3 years, from 2021, nothing was done. So I came to the court, filed a writ petition and got a direction. Now, even in contempt, if I'm feeling helpless, then it's a serious situation, Your Honor.
Yes, next.
Till number 44. Sagar V. Shastri.
So we have complied. We have complied with the order minutes. It's been filed. Court office. It appears that it's not been put up, my lord. The direction was to consider representation, my lords. Direction has been considered and endorsement has been issued. So page 7.
So it is your given promotion also. the grievance of the petitioner before a single judge, that his case for promotion to the post of forest guard was not considered, though juniors were promoted. Full stop. A single judge directed the respondents that the respondents shall consider the case of the petitioner in accordance with the stipulated time. Today, when the contempt petition comes up for consideration from figures on record, affidavit of compliance dated 6/3/2025, in which the respondent conservator of forest, Mysore Circle, has stated inter alia thus. Expecting from paragraph 3. Page 2, paragraph 3, the representation of the the representative complainant and considered. Selected. Just and proper. In the above view, the directions are complied with. Nothing is arise in the contempt petition. It is according with.
47 with the Tanuja MV, 47, 45 adjourned, 46 disposed, 47
Appearing for the appellant, kindly pass over.
45. Lordship, 46. Not 45, I am the complainant, but accused has taken an adjournment. 45, I am for the complainant. Accused, I am for the complainant.
respondent
Adjourned
to
is. You adjourn. Without asking you. 23rd. Great.
47
Appearing for the appellant, kindly pass over the matter as my senior is engaged in another court. Pass over the matter.
What is the urgency? Why is not there? You are there? You are Tanu?
I am for appellant.
No, very good. Like, you want appellant only. We want appellant only.
My senior is engaged in another court. Kindly
It is-
pass over the.
Ours is also a court. This is also a court. Do you think there's something else? Is it something else or court?
Is also court.
No, no, you call your senior. We will not going to adjourn it. What is?
Kindly pass over the matter.
No. First court is first court. You have to give preference. You must know the sense of priority when you argue in the court of law, in the high court. Yes.
Please, Your Honor.
Proceed. Please proceed.
Your Honor, I have not gone through the file. Kindly.
Learned counsel for the petition not ready to
Pass on.
proceed, dismissed on the ground of non-proceeding. So don't write it.
Your Honor, kindly pass over the.
No, don't write it. We will assemble at 3 o'clock.
Serial number 48. Advocate counsel son is admitted to the hospital. That's right. Appellant counsel son is admitted. Appellant counsel son is admitted to the hospital. Please kindly take next week. Serial number 48. I already informed to the other side also.
It can go to somewhere in April now. In April.
Yes.
Your Lordship's
25th.
Much of.
Your Lordship's permission, Lord. But item 47, which is the last matter which is called in the pre-lunch session, Lord. Request was made for Lord Passover, but I am told that your Lordships have dismissed it for default.
Who told?
I was told.
You just believe somebody's word.
Very well.
Not this. What do you?
Lord, I am ready with the matter, Lord. Your Lordship want me to go on.
It is not dismissed.
Very well.
It is only told that it is dismissed.
Very well.
Order is never translated. Not translated into.
Lord, I am obliged.
Today or any other day?
And some other day, your Lordship.
28th of March.
Yes. Yes.
The 230 matters, seal number 66,
Here for the.
Naveen Chandra.
Week of Passover, or if it's inconvenient, let us start. The senior counsel is just, will be coming shortly.
I can start my next.
This is to be heard, no? Main matter, both.
Yes, main matter. Since I saw the other two matters, after that it could be taken if it's okay, my lords.
Let this in council.
Yes. I'm great.
Is seal number 67, so withdrawal of contempt, Bala Nikit.
The order has been complied with. We have filed a memo for withdrawal of the contempt.
So and so for the British invites attention of the court to memo dated 5/2/25, stating that the order brought under the government jurisdiction complied with.
Memo was filed on 6th February.
In that view, applicant 6 permission to withdraw the contempt petition. Permission is granted, contempt petition dismissed as not survived. Disposed of as not survived.
Great.
Seal number 68, Amit Nayak.
Lords, I appear for the petitioner's counsel, complainant's counsel. Lords, I apologize, I was not here the day before yesterday, my lords, when the matter was called out. My lords, in this matter, the order, my lords, in respect of which we have filed the contempt, is in connection of sale of liquor in shops that are petty shops, grocery shops, tea shops in villages. They're not licensed shops. We have no complaint against the liquor being sold in licensed shops. When we had approached the Honorable High Court in the PIL, there was a specific direction that when women organizations in particular file complaints, they have to be complied with. Now the government has filed a compliance affidavit, my lords. Now the compliance affidavit has been filed by the junior most officer that is a party to this contempt application. Now, your lordship, the relevant portion, the affidavit is detailed, my lords, and I must compliment my learned friend for submitting a detailed affidavit. My lords, they say that they have passed a number of circulars to implement the High Court order. I have no complaint with that. The crux of the matter, my lords, is in Annexure R3. If your lordships come to Annexure R3 in the compliance affidavit filed by my learned friend. If you look at column number 3, that is period. The first column is period. Then number of complaints received. Then number of complaints received exclusively from women or women organizations. Then list the number at 405. Lord, this is the problem. We ourselves, my lords, the complainant here, my lords, represents the Mahila Andolan against
illegal sale of liquor, we ourselves have filed thousands of complaints and followed with a dharna to take action on the thousands of complaints. Now, my suggestion, my request, my lords, before this court is, I understand in contempt jurisdiction, your lordships cannot monitor compliance on a regular basis. My request, my lords, is let the chief secretary or the revenue secretary, who are accused number 1 and 2, file an affidavit. The reason, my lords, is we have written letters, and I have produced that letter as part of my complaint to the revenue secretary, to the DC, saying we have protested, we have held dharnas because our complaints are not being no action is being taken against the complaint. Now, my lords, this matter was also incidentally, my lords, because it's coming up today, I'm mentioning 2 days ago in the assembly also, legislators cutting across all parties have raised the same issue that we have been raising. And the minister has admitted on the floor of the house that illegal sale of liquor in these shops is continuing. So it requires, my lords, a response from the revenue secretary or the chief secretary saying what they have done. If your lordships look at annexure, my lords, in my complaint, my lords, I have produced. If your lordships look at annexure B6, B6, my lords, and then B19, we have said this. We have said we have filed many complaints and then no action is being taken. And then we are asking, what else do you need from us for action to be taken? The reason, my lords, and we have not rushed to the court just because there was one complaint, no action was taken against. My lords, even as I speak, my lords, there are protests going on. My humble request before this court is, because this is a matter where children as young as 8-year-olds are being affected because a tea shop liquor is being made available. Let the revenue secretary or the chief secretary file an affidavit saying what steps they are proposing to take and the actual number of complaints received and action taken against. That was the order, specific order of this honorable court. The order, my lords, is at page 15 and 16 of my complaint. The specific order, my lords. If your lordship look at page 15, the last paragraph, paragraph 5, as regards prayer B, it is the duty of the state government to ensure that if liquor is being illegally sold on a complaint received in that behalf, immediate action is taken for preventing illegal sale of liquor. If an organization of women makes such a complaint, it is all the more necessary for the state government and its officer to act very expeditiously, considering the rights of women. My submission is, I have no complaint against the affidavit that is filed. Maybe that is the details that that particular officer has. The senior officers who are A1 and A2, they need to tell how many complaints, because this is just one officer. The DC, we have written to the DCs of each district.
Counsel, the excise commissioner is the person who is involved, who is the highest officer over here.
Yes, my lords. But
It
the
comes
order,
under him.
my lords, the order, may I make one submission, my lords? My lords, the order is against. My lords, the order is against.
Excise commissioner. my
Excise
lords,
commissioner has filed affidavit. But my lords, it goes against the face of my own complaints. I have filed thousands of complaints. And that is on record. I have submitted, after the complaints, no action was being taken. I have submitted a letter again to the DC also saying, what more do I need to do? Now they produce a number saying 405. Because, my lords, the reason why I'm requesting this honorable, I would humbly request this honorable court to consider this submission is because on the floor of the legislature, my lords, may I pass on with my lord's permission. With my lord's permission, may I pass on?
My lords,
He is the highest authority in this case.
my lords, excise commissioner is the
My lords, only two submissions I'll make, my lords, and then I'll leave it to the court, my lords. And I just want to pass on, my lords, draw to the attention of the court, if my lordships permit me, the news report of the proceedings in the assembly, my lords, just 2 days ago, my lords.
Well.
Thank you. Your lordships look at page 5, the news report from Deccan Herald dated 5th March, my lords. Page 5, it talks about the ruling party MLA raising the question, and then members cutting across all parties. And then on page 7, my lord, just one line I want to draw the attention of the court. The minister conceded that liquor was being sold, illegally sold in petty shops on the floor of the House. This is not a public statement, press statement that I'm relying on. And there is a direction of this honorable court. Well, the seriousness of the matter, my lord, my humble request is, given the impact on young children and women, my request is let the principal secretary or the chief secretary file an affidavit detailing all the complaints that they have received and what action is being taken. And whether, because on the floor of the House also, they're saying that the government is pushing this illegal sale. It's contrary to what the affidavit says. This, my humble request is the court needs to consider this, my lord, because it's a serious issue affecting thousands of young children and women. And I appreciate I'm not trying to reopen the PIL. I will not press for any, after there's a proper affidavit filed by the secretary, my lords, I will not press for any continuing mandamus or anything like that. That's not the intent behind this.
For orders on traffic.
Much obliged.
Number 66.
Lord, may I be permitted to begin, my lord? My writ petition.
Sorry, last time the contempt is filed by us. So my lords, we had commenced with the contempt last time. And later on, my learned friend said that they wanted to file a reply, for which time was taken. Would like to continue so that I could continue my entire submission.
Reply is filed.
Reply they filed. They filed the
Contempt petition is not maintainable, my lord. For enforcement of an order, your lordship's court has taken that view.
the contempt and
The
one
direction of the
writs
Honorable
by
Supreme
us.
Court is to dispose of the main matter.
Where is the, let us see, Supreme Court order.
All the matters, the direction of the Supreme Court is all matters to be disposed. Yes. Contempt, if my lords just sees the list, there are 3 matters. The
Not them.
contempt is filed by the father, CCC 214, for non-compliance of the family court order. Then, my lords, WP 10508 is filed by the father again for challenging the family court order, because the family court order gave interim custody only till the end of the academic year. And we have sought that the interim custody should be till the pendency of the entire custody petition. And WP 6121 of 24 is filed by the mother challenging the family court order. That, my lords, in principle, they have only sought to set aside the family court order. That, in effect, becomes infructuous because the family court order till the end of the academic year is over. So, technically, their petition is now infructuous. That is my submission. I'll just go on to the my matter. My entire submissions, just for ease, the contempt has all the documents. If my lords could see the contempt and the entire paper book.
Where is that order up to?
The family court order, my lords? Yes, which my lord sees the contempt petition. It's at page 47. In fact, their petition does not survive because the family court order, which we challenged and are seeking the interim custody till the end of the petition, page 47. Operative portion 4 at page 84. at page 84 from there.
Page 80.
Ink page 84, in the order it is page 38. Yes, paragraph 44, my lords found that. Para 44, therefore, in the interest and welfare of the children, this court feels that till the completion of the academic year of the children, that was when it was filed, they have to reside with the petitioner and he has to take care and responsibility of the children and their education. Respondent, being the mother, is entitled to visitation rights whenever she wants to meet or visit the children. Prior intimation to the petitioner, she has to be permitted to talk with the children through phone or WhatsApp. If before academic year some holidays is accommodated, she will take the children with permission of the court. Then order. IA-2 filed by petitioner, that is me, my lords, the father, is hereby partly allowed. Respondent is hereby directed to hand over the children, Master Tiago Monte de Silva Sidhu and Miss Inez Monte de Silva Sidhu, to the petitioner for completion of their academic year education at Bangalore International School. And respondent is given visitation rights during vacation, both parties thereafter. So strictly speaking, I challenged it saying that just till the academic year is not going to be in the interest of the children. What will happen after academic year? Again, that question will have to be redecided. Children are with me. They were disturbed from my possession, from my custody. Therefore, they are asked to be returned. They have to be with me till the end of the petition. The mother challenges this, only seeking dismissal. Now, the academic year ended in 24. So, in principle, their writ petition, now what survives? That academic year is over. And status quo from last 10 months, from May, when the children were returned to me, and thereafter we approached the Honorable Supreme Court. Till now, this is a second academic year, which will now finish in June, I think. They're anyway with me. Let them continue with me. That's it. And anyway, the guardianship, so I am trying to say, of course, I will submit on merits. But where does their petition even survive anymore?
What was the prayer in the main guardian? What's
Prayer in the main guardian, my lords, it is at page 87. The prayer is to hand over the children to. I'll just point out to the prayer. Yes, at 114. 114. Prayer is to declare petitioner, that is the father, as sole and permanent exclusive guardian of the two minor children, pass an order restoring permanent custody, because she had taken them away from me on 1st December.
but only limited relief was granted.
I'm sorry. No, the permanent prayer is to for sole custody and guardianship to me.
But the order passed was limited, as you said.
Exactly. Order passed, interim order is passed is limited. In fact, that interim order is passed in such a way that after academic year, then again we would be stuck with that issue again. Yes, and no guardianship petition is filed by them. So what survives, my lords? We filed the petition because the children who were studying in Bangalore were taken away on 1st December 23. Thereafter, immediately we filed the GNWC petition. Give their petition. 6181. 6121. 6121. 6121. Please give me a paper. Keep it aside. And in the writ filed by us, we have sought that to set it aside to the extent that it is limited and to continue till the end of the proceedings, during the pendency of the proceedings. Our challenge was that it is limited.
Yes.
See, writ petition. There are two writ petitions, one filed by you, one filed by them.
Yes,
Both the writ petition challenge the same order.
yes.
Yes,
And the contempt is alleged
because.
against the same order.
Yes,
Okay. Admittedly, it's an interim order passed on an interlocutory application. Now it has spent itself.
that order has spent itself.
The order has spent
So
itself.
their academic year is over.
And the order also contemplates custody to be given to
The father.
the father
Yes.
till the end of the academic year. That's all. It does not examine after the academic year in whose favor it has to be given.
Yes.
Now go to the trial court and settle it there only, all both of you.
Continue, we are fine. Let the status quo continue. We and my lords can direct that. We are fine with that.
No, we won't say anything. We won't say anything. You simply go there and agitate, you file fresh interlocutory application if required.
We can do
Because
that.
it is not a main order, it's a pending matter.
Lords, we have no difficulty. The children are right now with me. She is coming and seeing the children every day. We are not interfering.
Whatever it is, we
Yes.
won't comment anything on that.
No, my lords may just have to continue the same situation, continue the same status quo. We are totally.
On the ground that the order has spent itself, reserving the liberty to both the parties to file whatever application they want.
So your order is worked out, petition is worked out, contempt is also worked out because of the nature of the relief granted and
And
the
the
relief.
nature of the facts that happened. But
Only
my
submission I have,
only submission,
only submission I have is this, my lord. It is by virtue of this order that the children who are in my custody were now in his custody. But for this order, they were in my custody.
No.
And I have raised,
But for
I-
which order?
but for the order which is impugned.
No.
There is an order, my lord, passed by the Domestic Violence Court in Goa, directing that the children shall not be disturbed from Goa.
You agitated that before the trial court only, sir.
The question is this, my lord, if that has to be done, status quo ante must be restored. It
Status
cannot be
President,
that
it can't be
it
status
cannot-
quo ante. Supreme Court has now given us a status quo order from the last 10 months.
status quo order of the Supreme Court is as it was then at that point of time. My lord, kindly appreciate this, my lord. Children, my lord, were with me in Goa. The marriage took place in Goa. The family resided in Goa. Children were born in Goa. In 2021, the family moved to Bangalore. And then, my lord, all these problems arose. In 23, my lord, the family got disrupted. And the children went with the mother to Goa.
Disrupted, they were taken away by the mother on 1st December. She leaves
Allow
on,
me to say
they
something,
are,
please.
there cannot be false
Otherwise, my lord,
submissions.
I can't argue, my lord, if every sentence of mine is being controverted, let her finish, my lord.
Responding to the honorable.
No, 1 minute, let me finish now, please. I understand your anxiety. I'm also anxious, but I'm not, my lord, screaming off. I'm only pointing out, my lord, the legal position. The legal position is that a court of competent jurisdiction, my lord, in Goa, which is under the Domestic Violence Act, examined the matter and granted an order. Now, please notice some dates. Now. My first submission is that the filing of the GNWC is an action without jurisdiction. That's why I am before your lordships under 227. Could the family court have exercised jurisdiction at all? Please notice these dates, my lord. The date on which, my lord, the DV court made an order is 6/12/2023. Your lordships will find that order, my lord. If your lordships would take my writ petition, 6121.
Sir, whatever the order is, it has spent itself.
No, but this.
Now, whatever, according to you, the valid order is, you people follow that. If you want, if you are aggrieved by any order passed by any court, you approach the appropriate forum.
But the status quo ante, my lord, it can't be, my lord, that by virtue of a court order, the status quo which prevailed has been changed. And the children, my lord, who are in Goa are now brought back to Bangalore. My lord, what?
You say the same thing before the trial court, sir.
Lord, it was a sharp practice. Your lordship should take notice of this. Your lordships made an interim order, my lord, on 8/4/24. This honorable court, the division bench, my lord, made an order. That order, my lord, was challenged by them before the Supreme Court, Bangalore. So the Honorable Supreme Court said, wherever they are, let them be there. So what I'm saying is, now, my lord, if that order has to go, the status quo ante has to be restored.
That Goa court order.
The Goa court order, page number, my lord, 170 in my writ petition, I've extracted that order. This is part of my application that I filed under Order 7, Rule 11 before the family court. I'll read the petition that I filed before the Domestic Violence Court.
To is there even in contempt? Just for ease, I can give the page.
In my writ petition, my lord, 6121.
I think in the best interest of the student, best interest of the kids, put them into a boarding school. And both of you exercise your visitation rights during holiday season. And try not to poison the mind of the kids so that they will grow up as better human beings.
I just want
It looks like you're playing football with the kids, the husband and wife, and traumatizing the kids and using them to take pot shots at each other. They'll be deprived of proper environs to become good citizens of the country or good human beings.
In fact, our only submission is children were here, studying here. There's no need to disturb them.
In the lighter vein, probably the society needs to look at Plato's philosophy of how he advocated communism of wives and how the kids have to be brought up by the society.
Like what they have in the kibbutz, my lord, in Israel, it's more or less something like that. Children, my lord, are communal children of the community. So they all, my lord, live in harmony, and in the olden days, my lord, even the joint families were like that. When they made no distinction between which brother, son, grandson, everybody were enjoying the same facilities in the house.
Probably something like that has to evolve in our society so that
the nuclear families, my lord, are sometimes
the kids are protected emotionally.
Exactly. That is the focus, my lords. Children have to be protected emotionally so that whatever may be happening between the parents, they are.
For that, you both have to part as mature adults. You have decided to part ways.
In fact, that
At
is
least
what
cause less harm to each other and no harm to the kids.
In fact, on two occasions, the Honorable Supreme Court referred the parties to mediation 2 times, my lords. In fact, despite that, Now, my lords, I just want to make a submission. Initially, the Honorable Supreme Court passed a status quo order in May. 10th May status quo order as on date. That time the children were with me. From May, children continue because they were just taken away by her in between. Thereafter,
They moved twice, so vacation
Thereafter-
wasn't allowed. Twice they moved
the stay vacating also was not allowed. My friend is instructing me. Thereafter, my lords, 30th Jan, again, the final order of the Supreme Court is continue the status quo as on date. My lords are absolutely right. It can be relegated back to the family court. The family court interim order has spent itself. Now, even after that, the children are with me. We will file applications for whatever extension, but the status quo as of now to be continued and the family court to be directed. Because otherwise, my lords, now they should not be disturbed. They are with me. They are with me. They remain with me, which is not disputed by virtue of the Supreme Court order.
And a prayer is to extend it.
And in any event, my prayer is to extend the children remaining with me till the GNWC has finally decided. In any event, that is my submission. That the children were taken away from my custody where we were staying together on 1st of December.
Supreme Court wants us to decide within 6 weeks.
My lords, the Supreme Court order is on the last page of 6 weeks, as early as possible, preferably within 6 weeks, the language of the Honorable.
Post this for orders on 20th. Supreme Court order.
Sorry, my lord.
For orders, anything to be submitted?
I'm sorry, I didn't hear my lord.
Anything to be submitted further?
My lords, on the merits, we are ready to submit on the merits. If my lords are relegating
I'll
it
take
to
my
the family
submission.
court, we have
We
no
have not
difficulty.
decided where we'll be posting for orders. If you want to submit that, you should take it.
No. My lords, we'll submit on merits. Ultimately, we are in my lord's hands. Even if my lords relegated back to the family court, we have absolutely no difficulty, as my lord said. But if my lords are sending it back to the family court, the current status quo, which is there now, to be continued. Tomorrow, we don't want the children again disturbed. That is our only anxiety. Ultimately, the family court can pass any order. Yes. May,
Or in order to save the time, you give the return.
my lords, we will give our.
Lord,
in fact, we
I'll
made
just
a
make a
list of
few
dates.
submissions, my lord, if my learned friend will
Yes.
kindly permit me.
No, but then I'll finish my submission on merits.
I've raised an objection regarding maintainability
No,
of the
I'll
contempt
finish with the
petition.
submission on merits. Where is
And
the
why,
list of-
why contempt it?
She's
No, I'll
bent
finish
upon
my
not allowing me to raise maintainability also.
Uh,
There's a judgment, my lord, of this honorable court holding
Yeah.
that the contempt petition to enforce an interim order is not maintainable. The remedy available.
There we are making exception to the rule by entertaining the contempt which is related to
My lord,
matrimonial.
the standard practice, my lord, has been, to my knowledge, my lord, any matter, my lord, whether it's injunction or other reliefs, if there is a relief available under the CPC, this honorable court is not entertaining contempt petitions.
That is correct.
Therefore, my lord, that is my objection regarding maintainability of the contempt. But in terms of chronology, my writ petition came first. So I would like to address your lordships if that is permitted. My learned friend's writ petition came later. She challenges a part of the order.
In any
Whereas
event,
I'm
I filed
challenging
the
the
contempt.
whole order.
I'm not really sure why my friend is objecting so much to me starting. I had started the.
Because my case is earlier. My 6121 is earlier to the other writ petition.
Contempt is also before my lords.
And contempt, I have already made a submission.
We'll hear the first petition. Your petition.
Please do. Lord, kindly take WP 6121. Lord, a few dates. The parties got married, my lord, in Goa on 11/2/15.
But then what will be arguing? Go, this is exhausted for itself.
Yes, my lord, I'll come straight to the issue. Yes. Kindly, my lord, the reason, my lord, why this problem arose is set out, my lord, elaborately in the complaint that she has filed before the Domestic Violence Court, which your lordships will get, my lord, at page number 32, annexure B. It's a very lengthy petition. I'm not going to, my lord, read most of it, but just show your lordships, my lord, what kind of treatment she was being given. Kindly go, my lord, to page number 47. Middle of that page. I started weakening as respondent number 1 would regularly pass night remarks about he not knowing as to where and with whom she was during the day, almost insinuating that she was cheating on him. The complainant states that she had 2 toddlers on her hands, and as such it would be nearly impossible for her to cheat on respondent 1, not that she wanted to. However, respondent 1 had roots of suspicion firmly sown in his dirty mind. This led to him slowly and steadily misbehave and ill-treat complainant in various ways. The complainant states that in addition to the above-mentioned emotional abuse during the period, respondent 1 also started subjecting her to physical abuse. The complainant states that respondent 1 started getting overtly aggressive while he was intimate in bed with the complainant and began hitting her, gagging her, slapping her while performing sexual act. The complainant states that she found a sharp change in the attitude of respondent 1 and tried to stop him from sexual relations with her in such an abusive manner. However, respondent 1 refused to stop and subjected complainant to marital rape on multiple occasions. The complainant states that she was too ashamed to discuss such a private matter with her natal family and friends. Therefore, she bore the torture of the respondent's silence. The complainant, however, did not broach up the topic to the respondent 1 in the privacy and brought it to the notice that she was not comfortable and that she found sex with him very rough and abusive, requested him to change himself. I'm not going to read the rest of it now. Please go to page number 52. These kind of things are continuing unabated. At the bottom of page 52, the complainant states that her children were admitted to Bangalore International School at Hennur and were picked and dropped within the complex by the school bus. The complainant states that they had a maid at their disposal who would assist the complainant in cooking and would clean the household. Complainant and respondent number 1 also had a car at their disposal. The complainant states that respondent at that point of time was working as a senior manager in AB in beverages, an alcohol beverage company, drawing an annual salary of 46 lakhs per annum. Respondent 1 has just before the separation of the complainant and respondent 1 had given notice of his old company, was slated to take up a job in Bangalore International Airport with an annual salary package of 56 lakhs. The complainant states that she was always into fitness and would regularly exercise to keep fit. The complainant states that being an outgoing person, she soon made friends with people in the complex. The complainant also made friends with Colonel Girish Reddy. Then, my lord, comes this other person with whom such allegations have been made. The complainant states that there was an APL tournament which was being organized in the complex. There were teams which had been made for participation there. Colonel Girish started training the team of the complainant, and as such, he started running and training with him for some time. It is through this Colonel Girish that she met this young son, Jay Reddy, who was also known as JD. The respondent number 1 again had problems on this front as well as was unhappy because the complainant was socializing and making new friends. Respondent 1 also started having problems with complainant getting up at 5 a.m. for running within the complex, which was something that she had been doing all throughout. That is why she was living in Goa as well as Bangalore. Furthermore, respondent 1 started having problem because complainant was working in their family dog Bella besides JD family dog Tufan. The complainant's dog was required to be exercised 2 to 3 times in a day as she had thyroid issue, and JD would instantly join her as his dog was found of Bella. The complainant states that there was no relationship between her and JD, and they were connected only on a purely platonic level. The complainant states that the respondent 1 had a problem with this as well and felt threatened by JD. Respondent 1 started behaving in a very immature manner and forbade the complainant from walking Bella and JD's dog. Complainant found this act of respondent most juvenile, and since then, she on her own did not choose to call JD whenever she was walking her dog. Now, then my lord, kindly go to the next bottom of that page, about 4 lines. The respondent number 1 would not make time for the complainant, would not try to converse with her or change his aggressive behavior in bed. On the contrary, would scream and shout and dominate her on many occasions, also in the presence of their children, and would have forceful, painful, abusive intercourse with her as he wanted to teach her a lesson. Complainant states that respondent 1 would be overtly aggressive even if he heard the name JD, and had complainant recalls one occasion when the complainant and her daughter were talking among themselves just before bed at night. He thought he heard and then named JD in the conversation, whereafter respondent 1 became ballistic and shouted at the daughter of the complainant, making her cry, and thereafter created a huge fight with the complainant and went on till 11 p.m. Then, my lord, next page, 59. About 5th line. She tolerated this for some time. The complainant therefore moved out of the bedroom of respondent number 1 and started occupying a different bedroom in the same house. The complainant states that this triggered the respondent and even more. He would come to the bedroom of the complainant, shout on top of his voice, create a humongous fight in the middle of the night, and would rape her anyway. This is how, my lord, she went on. And the rest of it, my lord, is the elaboration of this torture that she has undergone. And the prayers, my lord, are at page number 79. She asked for a monthly maintenance of 1.5 lakhs. Prayer B is to restrain respondent from interfering with her life and threatening and abusing her children. Then an order for maintaining the custody of the minor children, and orders restraining respondent from claiming through or taking forcible custody, and other reliefs. On this, my lord, the lordships would now turn to page 170. In my affidavit, I've extracted, my lord, the text of the order issued by the learned magistrate. Paragraph 4. I state that I filed the aforesaid petition on 6/12. It should be typo error, my lord, it's 2023, not 24. The Honorable Court in Goa is pleased to pass the following order. Issue notice to respondent. In the meanwhile, ad interim ex parte relief, interim prayer C is granted till the next date of hearing. Now, my lord, this order is passed on 6/12. This current petition is filed on 14/12. My lord, in the Domestic Violence Act, section 28, subsection 2 may kindly be seen. Provides an exclusive jurisdiction.
The JWC petition is filed as an annexure over here.
Yes, ma'am. It's an annexure to, just now what I read is an annexure to WP 6121.
The GNWC, I filed it in mine as well. in the
That is
contempt
annexure D, ma'am. In our petition, it's annexure D at page 91. Section. Judgment. Division bench judgment.
Which says it. 15 December 24.
division bench.
16 judge. Okay. Now, this issue has been considered.
May I pass on the judgments of?
Proceedings are not originated from this.
Pardon, my lord?
Proceedings leading to the filing of these petitions
Yes.
do not originate from this act.
No, Lordship, the GWC.
No. The GNWC
And,
Act.
and there's a subsequent order of the DV court which says that the GNWC proceedings will prevail. Nothing will stop it from prevailing. That order is not being pointed out.
How can-
15th of December
How
order.
can we restore the order under this act?
Yes, that is not at all in question before my lord.
No, all that I'm
Yes.
saying, my lord, is that
That-
there is now, my lord, your lordships will see, there is an order passed by the court under the DV Act that children custody should not be removed, should not be disturbed.
Not
Now
question.
there is an order passed by the family court here saying that father must have the custody. Now, because of that order and by
And the order
virtue
is
of that
clear, I think.
order, children who were in my custody, I've also raised a question of jurisdiction.
In the contempt is 232.
The children, my lord, were at Goa. Marriage was at Goa. Parties were living there at Goa, but I admit that in 21, my lord, the family moved to Bengaluru. So
You did not pursue that order further?
They in fact are
It is
not
pursued.
pursuing.
The matter only. They not file income affidavit also?
Last date, from the last several months, the domestic violence proceedings which the wife has claimed to file, she
Yeah.
is not at all proceeding with it.
Yes.
So where is she can definitely proceed with it and take it to its logical conclusion. She's not at all appearing there and she's not at all proceeding with it. And after this order, after that initial, there is another order. All of that was where I got interim custody, where all of that is there before the family court. That is not in question.
Lordship, may I?
That is not at all in question, the DV Act.
Lordship, may I make a
but
submission?
may I
Lordship?
continue?
Can continue, but
I have to continue, I'm permitted, otherwise. Now, my lord, in those proceedings, parties appeared and they filed a joint memo. Yes, in the DV proceeding. Please, my lord, turn to page 89.
So how can we travel to those proceedings in the record thereof?
No, what I'm saying is, the father subjected himself to those proceedings and filed a joint memo in that.
To
And
the-
now, my lord, can he come and take a different stand and file a different proceeding in a different court? What is the conduct? Because when he consented,
What is the joint memo?
joint memo is that she can keep the custody. Please see page 89, my lord.
For a period of
Visitation
10
rights only for the father.
week, how to distribute visitation for 10 days. That's it.
I'm going to read it, sir. Why don't you have little patience? I'm going to read the document. Page 89. This is a schedule for visitation. Now, I'm told the copy in this is slightly illegible.
Typed copy is available in the objections to their repetition lots at page 31.
In which matter?
In the objections to the writ petition filed by the other side, a better copy is available. I'm sorry.
So writ petition 6121.
No, in the other, that is 10508.
My contempt, if my lord has my contempt.
Okay, I'll-
it's a page, it's a better,
Yes.
it's a better copy.
I'll read from there.
Start without prejudice.
At page 250 of the contempt, the joint memo which they gave, it says without prejudice, just for few days they had. Page 250.
I think
Same.
ನಾನು ಕೂತ್ಕೊಂಡು ಬಿಡೋದು ವಾಸಿ ನಾನು. ಅವರೇ ಮಾಡ್ಲಿ ಅಂತ.
Probably my post money and.
So, my lord, on 6/12, there was an interim order by the domestic violence court. Thereafter, notices were served, they appeared, and this is, my lord, the joint memo that is filed. Without prejudice to rights and contentions, the applicant father and respondent mother have agreed to the following arrangement for exercise of visitation rights by appellant for the period 21/12/23 to 6/1/24. Daily visitation, children to be picked up, etc. Overnight custody, weekend custody. shall not take the children out of Goa. This is signed, my lord, on 21/12/23. Your lordship's interim order, my lord, in this writ appeal is 8/4/24. It was a joint order, my lord, in the contempt and the writ petition, 8/4/24.
Madam, if somebody goes to enforce this order, this memo, then
Lordship, it's,
No, that is joint,
it's only for a limited period. 6th of January.
only, in fact, it is only till.
There's an order
6
made by
months.
the court on this joint.
In fact, the same domestic that, two submission forms. One is that this joint memo was only for
10 days.
two submission forms. One is this joint memo was only for 10 days
10.
because she had rushed and taken away the children. And I ran there to get access to the children and there was a joint memo filed. That same DV court, whose proceedings are not questioned before this honorable court, the same DV court, in fact, had passed another order on 15/12 wherein they stated that the custody proceedings are pending before the family court. And in fact, I read out saying, considering the temporary nature of the orders provided under this act, which is under the DV Act, they are only temporary orders. This will not come in the way of the parties seeking custody of the children before the family court in Bangalore. DV Act are only temporary orders which are temporary in nature. Ultimately, if a party wants to seek custody, mother of.
where you are reading?
Yes.
No,
kindly
232,
see,
contempt.
My contempt.
32.
Compilation. Yes, page 232. That is also the, page 232. That is also the order of the same DV court in Goa, which says that we don't have ultimate powers. 232, para 20, my lords. This is the order of the Goa DV court. From 19 onwards, para 19 I read. It is also made clear. My lords found it, page 232, para 9. It's also made clear in this order that custody rights provided in section 21 of the Domestic Violence Act are temporary in nature. This court has not decided on temporary custody of the applicant in the present order. They've not decided on temporary custody and has merely decided on limited visitation rights. The respondent number 1, as per his own submission, has also approached the family court in Bangalore for seeking custody of the children. Considering the temporary nature of the order provided under this act, this order in any way will not come in the way of parties in seeking in the any nature of custody of the children before family court in Bangalore. Those were limited proceedings where till we were awaiting the interim custody order of the family court, I can't be without seeing the children. I went there was a joint memo filed till 1st of January or 6th of January, you will see the children. Then my main proceeding seeking custody before the family court under the Guardians and Wards Act. Interim custody I sought. The interim custody was given only till the academic.
And Lordship, interestingly, this order also said that I can bring the child back to Bangalore for the sports day for 72 hours, which was also breached by the wife, and the contempt was filed there also. Even this order was not followed by the wife. Also, the order passed by the family court on 6th of February was not followed by the wife for so many days, and when the contempt was filed. Now, Lordship, one thing I just want to point out, my learned senior friend said that the Supreme Court must have passed the order because the kids were with me. Lordship, I argued the case before the Supreme Court at that point in time on 10th of May. What, Lordship, we had pointed out was the conduct of the wife. It's not a case that they're playing football, because it is the mother who was caught red-handed in adultery.
I'll continue with
Yes.
this. If Mr. Naganand has finished, then I can.
I haven't finished, my lord. I was sort of interrupted, but I'll continue. My lord, now please see the GNWC case that is at page 91. Yes. In my writ petition, 6121. several allegations are made, mainly about an incident which is supposed to have happened, my lord, on 17/9 and on 24/11.
17.
Now, the veracity of that has been denied. In the objections filed, she has specifically stated that such an incident never happened. And the allegations are scurrilous and they are completely false. That is a stand which still has to be tested now. It's their word against my word.
Affidavits, witnesses.
The petition is replete, my lord, with a lot of insinuations. And the main prayer, my lord, is at page 124. Most of the averments here have nothing to do with the subject matter of the case regarding custody. The attempt appears to be just to paint the mother black. First prayer, my lord, is declare the petitioner as the sole permanent exclusive guardian of the two minor children, to pass an order restoring the permanent custody to petitioner. That means, as on the date of the petition, the father did not have custody. The children were in the custody of the mother, going to a school in Goa, staying with her grandmother, the grandmother, who has given a lot of benefits to this father. Even a gift deed is executed for some land when things were good. And then, my lord, the interim prayer is at page 126. Please see the prayers at 131. This is IA number 2. The first prayer, my lord, at the bottom of page 131 is allow the application under section 12 and grant sole interim custody of minor children so and so during the pendency. This is the main prayer. This is an alternate prayer. Grant interim visitation rights to petitioner in respect of minor children in the manner delineated below. So he is happy with this also. Overnight access, visitation rights, temporary custody for vacation, then audio video, and for consultation regarding school curriculum, etc. The Honorable Trial Court, my lord, did not grant an ex parte interim order. So an application was filed before this Honorable Court. And in that, my lord, a direction was issued that the matter should be heard and an order should be passed. The objections to this, my lord, is at page 140. I have, my lord, specifically denied all these allegations, and I have pointed out how the conduct of the petitioner was so difficult for me to manage. More or less, my lord, whatever I've said in the domestic violence case, I have not placed before the court. I've specifically denied these allegations about some naked person in the room and etc. like that. I filed an application, my lord, in the Order 7, Rule 11 at page 168. On the ground that the children are not within Bangalore jurisdiction. There is already a proceeding under Domestic Violence Act. That application, my lord, was not considered. Only an order was made, my lord, on IA number 2. Lord, after noticing the submissions and the arguments, my lord, the merits of the case, my lord, are considered from page 198 onwards. The decisions are noted. At page 205, court has taken note of an alleged incident which is seriously disputed, para 35. Two factors are noted by the court. One is this. Second one is the so-called affluence of the father in having paid a huge fee to admit the children to school. May I read para 35? By relying on the facts of the case and documents on record, counsel for petitioner argued that the children are 7 and 8 years old. On 25/11/23, incident was occurred in the house. At that time, one Jaya Aditya was found naked in his bedroom with this respondent. And prior to that also, there were many incidents regarding communication between the respondent and Jaya Aditya. When the respondent found red-handed, immediately she left the matrimonial house. She has booked only her tickets, not the children's ticket, because the incident happened on 25/11 and she left the house on 26/11. At that time, children were in school. After 4 days, she came along with her mother on 1/12/23 and taken the children without consent of him and parents. Thereafter, he has communicated with her. She has filed a false complaint against him before Goa court. He appeared before the court and filed applications for visitation rights and to take the children to Bangalore for sports day as well as birthday of daughter. The Honorable Margawa court was granted orders in favor of petitioner. Counsel for petitioner further argued that after the incident, his mother talked with the father of Jaya Aditya as well as talked with the mother of respondent. The counsel has drawn attention to the document regarding conversation between father of Jaya Aditya and petitioner, respondent's mother and Jaya Aditya, which is about 26 minutes, and also communication between respondent and Jaya Aditya regarding to book the stay at Koramangala. Counsel also drew the attention of the court regarding birthday celebrations. All the birthday photos discloses respondent is very happy with children at home prior to left the Bangalore. To support her arguments, she has also relied aforesaid decisions regarding jurisdiction as well as custody of the child. On the contrary, counsel for respondent argued that petitioner has exercised his visitation rights as per order of the court at Murgaon, but it was not mentioned in the present petition and suppressed facts. The main contention taken by petitioner is that respondent will move along with children abroad, but passports are with petitioner. Further, it was argued by relying their decision and evidence on both sides, court has to decide the custody of children. Therefore, at this stage, the children are with respondent. They are studying at Goa. Therefore, this court has no jurisdiction and petition is not maintainable. There is no dispute about the marriage of petitioner and respondent. There are two children, namely so-and-so. It is admitted fact the children are born at Goa. Until 2021, they resided at Goa. It's also admitted that after 21, petitioner respondent shifted to Bangalore with children and studying in Public International School, Bengaluru. The petitioner has produced school receipt. Children discloses that that on 14/7, the petitioner has paid 4,14,000, 4,40,000 Bangalore International School. Document is sufficient to hold the children were studying at Bangalore. Petitioner has spent more than 8 lakhs for admission. He's taking care of children and their education. It's admitted that respondent is not doing any work. Petitioner has produced the communication between petitioner and Jaya Aditya as well as on the date of incident. He came to the house of petitioner. Screenshot of CCTV photos are also produced to prove the incident. Petitioner has also produced air ticket of respondent only, which is dated 26/11. The photographs also produced regarding visitation rights enjoyed by petitioner at Goa. Main contention by petitioner that even though court orders for visitation rights as well as to attend school by children, respondent always avoided. Even though in the present case, 2 times direction is given to respondent to keep the children before the court, was not complied by respondent. The attitude of respondent is very clear that she is avoiding children to meet petitioner, even though she is not complying with the court order properly. Photographs produced by both sides discloses children are comfortable with both parents. Whether who is entitled for sole custody, it has to be decided after a full-fledged trial. Considering the facts of the case regarding respondent has taken children without informing petitioner his parents to Goa, she has admitted the children in Goa as she has produced 2 receipts dated 16/1/24. Children were studying in a reputed school. Petitioner has also paid huge amount for the admission till 26/11/23. He has taken care and welfare of the children. No single allegation regarding harassment by petitioner to children. Therefore, considering the facts of the case and documents on record, at this stage, interest and welfare of children has to be looked into. From 1/12/23, children are not attending school. The dispute between husband and wife, but children were suffering. If respondent has love and affection with children, on 26/11, she alone left Bangalore, and after 4 days without information, she came to Bangalore and took the children itself, shows her attitude, and without taking consideration of the welfare and education of children. She took away from Bangalore. She has not at all considered academic care and education. Petitioner is capable to take responsibility of his children, and his parents are also residing with him. Then, my lord, he has produced receipt, etc. Next paragraph relates to, my lord, more than one relief, my lord. It's a very technical objection. I don't want to, my lord, press that seriously. Then, my lord, next page, he says he is financially solvent, and therefore, it is better that they come here. And at page 40, para 44, because it was that middle of academic year, the court said for this academic year, they should reside with the petitioner in Bangalore. Lord, my submission, Lord, is this, that before adjudicating on the veracity or otherwise of various allegations that are made, I cannot be, Lord, painted black. And it cannot be taken that an allegation made like this is true. The harassment that she has suffered, my lord, is set out in her petition. I have repeated it in my objections also. So the learned judge doesn't go into any of those things. Whether I was harassed, what is the reason why I had to leave the matrimonial house and go away? My lord, for a mother to leave her children and go away is very difficult. What is the series of incidents, my lord, that she has referred to, which has forced her into a situation like this? Please consider, my lord, a woman, my lord, has certain restrictions. She cannot do everything that she wants. And this is the suffering that she has suffered. So for that reason, if she goes and she feels that the children are going to be looked after, because, my lord, as I said, children are all born in Goa. They are bonded, my lord, with her mother. They were living there. Her mother has given him a property. A gift of a property is made to him. And they were living there quite happily. So the children are not uprooted to some new place. They are in a comfortable place. And the father, my lord, one more aspect. One is this personal, my lord, conduct of kind of a very, very strong violence against the mother. But other thing, my lord, is that in the latest affidavit they filed, they say he didn't have money to pay school fees, so he had to borrow money. Now, my lord, on one hand, fees, the only reasoning given by the learned judge, my lord, or the main reason is that he has paid money and got the child admitted. I have also paid money and got the child admitted in Goa, the children. So I don't see, my lord, how the court can take the word of the father as gospel truth and castigate the mother. Lord, in the objections to the other writ petition, my lord, I've placed some facts as to what all has been done by our family to him. When they shifted to Bangalore in 21, the mother-in-law sent, my lord, 4,12,587 to him to settle down here.
Petitioner paid.
And also in addition to giving him immobile property there. Now, my lord, so to say, my lord, he wanted, my lord, for the school fees for 23-24, he said, I don't have money. The learned judge, my lord, thinks that he's given the money. 6 lakh rupees was given by the mother-in-law, his mother-in-law, to him for this purpose. So the entire reasoning, my lord, of the court, that he is very affluent, he has paid school fees of so many lakhs of rupees. Out of that, my lord, out of 8 lakhs, 6 lakhs was given by my mother. These are not factors, my lord, which would weigh so far as the children are concerned. The children, my lord, must have, my lord, even on the visitation that she came to Bangalore, her bills have not been paid. There's a direction that you should pay. No maintenance is being given. She was doing some small petty business, which she now cannot continue. So in a situation like this, my lord, my submission, my lord, is this, that on an overall conspectus, the mother, my lord, must have the right to keep the children and bring them up. Father can certainly have right. Not when a man is very busy in his own work, profession, my lord, the time that we spend with the children is constricted by our professional and job requirements. It is the mother, my lord, who looks after the children. Today, my lord, children go to school at 7:30 or so, come back at 2:30 or 3 in the afternoon. So who is going to look after? When is the father going to come? What is the time that father is going to spend? I have also made a statement that the only time we were spending was in the evening for some time. Now, my lord, because of this visitation order, now, my lord, the visitation rights given to the mother, she, as I said, my lord, she lives in Goa. Children are now in Bangalore. So visitation every day means she will have to come and stay here. Otherwise, it's not possible for her to take that visitation also. So she is now torn between everything. If she comes here and she is going to live here, she must be maintained. There must be some proper accommodation that is provided for her. Costs must be met. If that is not done, and simply you say every evening you can come for visitation, it makes no sense. On festival days also, my lord, and vacation time, she has not had the benefit of the children. And the children have had the benefit of the mother.
So, anything you have to submit?
Yes, I'll just take my lords briefly. My lords may just see the contempt. My lords may see the contempt.
May I be excused, ma'am? Grateful.
I refer to the pages in the my friend wanted to leave since he had other things. He could have definitely said I would not have had any difficulty in accommodating. My lords may just see the contempt petition because I'm referring to pages from there. My lords, they came to Bangalore in 2021 and everything was fine. There was absolutely no difficulty. Kindly see page 129. All the submissions of any violence, domestic, nothing was there, nothing was fine. At page 129, on 25th November, at night, page 129, 23:42, at 11:42 in the night, there is a gentleman who's walking out of my bedroom, out of my house. This is the CCTV camera of my house capturing him. He is walking out. In fact, before he ran out, I go into my bedroom and I see him stark naked with the respondent in my own house. Then he runs out and the CCTV camera catches it. At page 133, immediately at 11:45 p.m. at page 143, I call respondent's mother, my mother-in-law. She does not take my phone initially. And then my lords may see at page 138. She then takes my call at page 138. This is the transcript of the call, which is completely recorded and maintained. At page 138, if my lords can just see that one page, 138 is the transcript around the middle, around 10 lines from the top. At 1:48, he tells her, Shardul Sidhu, he tells her, he calls her mum. She's his mother-in-law. Mum, sorry, I'm messaging you so late. I'm just so shattered. I can't sleep. I can't even close my eyes. I'm just so heartbroken. I can't explain to you what it feels like to see a naked man hiding under your wife's bed. I just can't get that image out of my head. Please help me, mum. I don't know what I've done to deserve it. Then she calls him and they have a 26-minute call. Then he says, again, I'm sorry if I'm repeating. I don't know what, you don't know what I'm going through. Then kindly turn to the next page.
136.
139. 139. I'm sorry. I'll go back to
136.
136. I'm sorry. My lord, kindly turn after that conversation at page 136, if I may refer. This is a conversation again on the same night on 26/11 with that gentleman, Jaya Aditya's father, who was their neighbor. That gentleman and his family live next door to us. At page 136, about the fourth line, he talks to him and says, well, I don't know if an apology cuts it, given your son was naked in my wife's room hiding under her bed. Page 136, my lord, around the fifth line from the top. Girish, he's an retired army person, my lord. He's the father. He says, I understand. Then he says, we have spoken to him. Is it possible to speak to you in person tomorrow? This is about the 7th or 8th line. Then he says, have you been able to speak to Gabby? We are also very disturbed. Could we meet and speak? JD is not around till 1600. Could we meet at our place somewhere outside Augusta? Then Shardul Sidhu says, my dad is here. Please allow us some time. We'll speak with you. Then he says, okay. Girish says, is he aware? Then they say, they flew in today morning. Yes, they are aware. As soon as this incident happened, he calls his parents. They come there. And then they speak to the father of the boy. Thereafter, my lords, after this incident has happened, kindly see, my lords, at page 208. When she was caught with this person in their house. Page 208, my lord. Page 208 is a ticket dated 26th November. Immediately the next day, this incident happened on the night of 25th November. Yes, 208. She books a Bangalore-Goa ticket for 26th November morning. Single ticket. She flies out. And then, my lords, she flies out without the children, without anybody. Then she comes back on 1st December. Kindly see, my lords, at page 212. Page 212 is she books on 1st December an Airbnb in Koramangala. She books a flat, which means she has no shortage of resources. 212, my lord. She books a flat because she does not want to come and stay back in the house, knowing that she was caught finding what she had done. And then on 1st December, she comes, stays somewhere, comes with her mother and brother, forcefully takes away the children the minute they come back from school that day, and goes to the airport and takes them off. Immediately on that day, at page 215, she stops taking my calls. Kindly see, my lords, at page 215. I send her a message on 1st December when she has kidnapped the children like this from the house. I say, hi, Gabby, I really feel, my lords found that page, my lords, 215. I really feel the way you took the children from home without me or dad being there, and mom kept asking you to wait for me. She comes only when my mother is there. And mom kept asking for you to wait for me to come was so wrong. You told her you are going to an Airbnb in Bangalore. Why didn't you just tell her the truth that you were planning on taking them back to Goa? Why did you bring your mother and also along? What was that meant to be? The only thing I'm worried about is the children and them seeing you rush off in a taxi right out of the bus from school. She goes to the bus stop. Was just so wrong. They would be scared seeing all this. I hope you hold true to our conversation at the airport and get the children back for school on coming Monday. They have their sports day practice Monday onwards. You can check their school mail, and I would really appreciate and request if you could just bring them back to their school and their routine. They don't need to be exposed to this. Please let me know what flight we'll be taking. Would arrange for a pickup from the airport. So on 1st December, she rushes, takes the children straight from the bus stop, takes them to Goa while they are studying here and have school going on. And then she goes there to Goa, files this so-called DV case. I rush to Goa. I try and see them there for a few days in between on weekends. Then there is a 15th December order there saying that you can take them for a few days, where the DV court says this is just a temporary order. The custody order should be in Bangalore. I filed the custody petition here on, I think, 13th December. And then I get the interim order that she has disturbed their schooling and they have to be brought back. Now, my lords, after the interim order is also filed, she does not bring them back. And my lords, I would like to, on 16th January, in fact, my lords, I have filed 2 additional documents. May I just request if the court officer can assist? One, my lords, is a memo of documents filed 2 days back in 10508. And one is a application to bring on record certain additional documents in the contempt. And all the 3 matters. Two sets of documents are filed. One is IA to bring on record additional documents. That was filed, I think, about 10 days back. Sir, I can check that and I can show it. I can confirm. It says application to bring on record additional facts and documents. I'll just show it. Court officer can just show me, I can come. Sorry, there are a lot of documents. This is one, but there is another one. There's only one. Application to bring on record certain additional documents. One more document. Application to bring on record. So one more is contempt. No, application to bring on record. Contempt in contempt. Maybe 125. This IA is in contempt.
In contempt.
1.
Then it must be 1. So in contempt, IA 1 if you can give. So this is what IA 5. IA 1 is. IA 1.
Yes.
IA 1.
Well, yeah,
My lord sees this compilation at page 58. Page 58 is on the left hand. Yes, the slightly blurred document. What the mother does, respondent does, she takes them away on 1st December. Thereafter, in January, she admits them to some Manovikas English school, but she she just takes an admission form. The school is not, they are not admitted or attending that school. They attend the school for a mere period of 9 days in March. Kindly say that is the attendance date given by the school on page 58. Attendance record of students. This is the page. It's a little blurred page, unfortunately. Page 58.
58.
Page 58. 58.
Ah, it is there, yes.
Page 58. On the left-hand side, Manmovikas English Medium School attendance record of student. 1, Ines, which is the girl, my lord, class 2B, March, number of days, working days 12, number of days present 9. 9 days in March and April about 2 days. And the boy, Tiago in class 3, March 10 working days present, 10 days present and number of days in April 2. So hardly 11 or 12 days they attend in March.
And April.
Now, March and April. Now, my lord, I just want to pause here. From 1st December 23, my lords, kindly make a note. They have been whisked away from Bangalore. They are in no school. They were admitted here. They are sitting at home, children in 2nd and 3rd class. They go back to school in March. 12th of March for 9 days and 2 days in April. So from 1st of December, January, February, March, 3.5 months, children are out of school in an academic year. And that is why in February, in fact, you cannot have taken them during their academic year. They say that in 16 January, they took admission in Goa. They may take any admission, but their children join in the middle of the year. Show that she has taken admission. It is a school which belongs to some relative of hers, where they immediately got admission and 9 days they have attended. That's it. Thereafter, my lords, the interim order were passed. They came back to Bangalore on 5th of May. And on 5th, they resumed their school because here, my lords, the school is an IB school. It is an International Baccalaureate Board. In fact, my lords, it is not the father is paying the current school fee. In fact, my lords may see in the same compilation at page 150. Page 150 is their current academic year. Also, they are continuing. He has paid about 5,38,000, 5.5 lakhs for both of them.
Each of them.
For each of them, sorry. 5.5 lakhs for each at page 150. 11 lakhs he has paid. And he has taken a loan to pay, not because he doesn't have the money, because now you get educational loans at very, very
0%
interest rates. So it is a convenient way to raise the fee. Ultimately, my lords, he has paid 11 lakhs. Even last year, he has paid 8 lakhs, 9 lakhs. They are studying in the best International Baccalaureate Board school here. You take them away on 1st December, keep them out of school for 3.5 months, then put them just to show that you have taken some admission in any school there. They attend for 8-9 days. And then we have, by orders of this court and by further status quo orders of the Honorable Supreme Court, they have continued. They have been in Bangalore International School, my lords, since 2022. And we are now in 25. They have settled well. In fact, in the same compilation, even their results are given.
Yes.
Their results are at page 158 onwards, where the school has said the children are extremely well settled. Children are here with the father and the father's parents, the grandparents. The father's father, the grandfather, the children's grandfather is a retired army officer. Their grandmother is a retired school teacher. She has been a school principal for the last 20 years. Of course, she's retired now. So they are staying here in an extremely wonderful environment. The mother, my learned friend said that the mother has to stay here. Yes, she's staying here. She is staying here, and in fact, the school children should never be disturbed. My lord said that yes, children should not be treated like a football. My lord, that's exactly right. Children have to continue where they are going to their school. We have not changed their school. They have their friends there. In fact, from from page 194 onwards, my lords will see all the activities. Which school is one of the best schools, taking them for activities, picnics, and all other animal shelter and all other related activities.
Camping trip.
Camping trips, all of that. Now, my lords, the status quo of the children are well settled here. We have no difficulty if she comes and visits the children in the house. We are not stopping. We have burnt our fingers where the minute she was taken the children out, she has absconded to Goa. In fact, even till date, we don't know where she's residing in Bangalore. A submission is made that you pay for her stay. I will pay provided I know where she's staying. She says, I'm staying with friends. My lords, what kind of stability is there if she's staying with one friend or with one day and another friend with another day? Even her address is not given.
We are posting it for orders.
My lords, I have
Chats.
given a detailed list of dates. My lords may find that useful.
That's one this thing I would like to.
Given this list of dates on the last.
May I just-
I've given.
Lordship, I just want to point out just one bit. Lordship, there are not only chats with respect to that incident. Now, I was never aware what was happening with my wife because I thought everything is hunky-dory. However, in the month of January of 2024, I chanced upon chats where she is also, Lordship, all those chats are on record, where she is also admitting to be bisexual. These all chats are on record. And Lordship, the kind of chats which are here, we were shocked to see all of that. And the person with whom the chats were exchanged, they've also filed affidavits, and which is on record. And we've also filed this before the apex court. These are all matters of record. Now, in such a situation, and also each time she's trying to tutor the kids by saying that different things, and that the father will be a stepfather, and there will be that she'll be the mother, and why can't you have two fathers, and he will be the stepfather who's the biological father. These kind of things are being spoken to the child. And the only reason why she moved to to Goa, Lordship, with the kids, Lordship is well aware, because if she's found living in adultery, she's not going to get maintenance as per law. Some judgments say that. So she felt the only way she can get maintenance is to take the kids with her. And which is why she has stopped proceeding with the matter in Goa, absolutely, because she knows there's no point asking for maintenance when the kids are here. Now, Lordship, now when she also tries to speak about the fact that she doesn't have the money, Lordship, the mediation through the Supreme Court, first round of mediation failed in 2 days. And the apex court again said that you must go for mediation, try to settle the matter. So the next round went on for 2 months. And Lordship, that also didn't get settled. At the end of the mediation, she went and bought herself a new car. She's saying she doesn't have money. Lordship, we have the RC. She went and bought herself a new car, a 17 lakh car from her own money. And she's saying she doesn't have any money. And in the DV complaint, she's saying that she belongs to a very landed class. She's staying in a 3,000 square meter house in Goa, which is in her name, her mother's name, and her brother's name. They are landed people with multiple properties all over, which is why she's not even filing her income affidavit anywhere. Because the minute her income affidavit is filed, she will not be entitled to any maintenance. She'll have to disclose all her assets.
5 minutes. I would just like to point out their own documents, Lords. They filed a memo with some documents in my WP, Lords. I will not take more than 2 minutes of your Lordship's time. In this memo, Lords, the first document that is submitted by them is the renewal agreement to lease, where after shifting to Bangalore, they take up a house and later on they shift to Augusta Golf Village, where the petitioner in the contempt, the father, is presently residing. In this renewal agreement of lease, my lords, if your lordships were to see, the address, permanent address given to the father is the address of the Goa. And they have submitted, the first document is the passport. There again, permanent address of the father is the Goa address. Plus the marriage certificate they have produced, which is of Goa. Everything shows the parties are permanently residing in Goa. In fact, my lords, the parents on either side are still residing in Goa. Because the father's parents, my lords, have some business and they are residing in Goa, and her mother is permanently a resident of Goa. So Goa admitted to the Gera school, studied till 2022. Only for about 2 years, they shifted to Bangalore. And my lords, if my objection to their WP, my lords, I would just like to point out one para, my lords, where what he does after taking a status quo order. Lords, I'll just point out that para 20, the respondent. 20 of my objections. But I'll just take your lordships to para 18 middle, my lords. For about 7th or 8th line. My lords, the school in para 18, my lords. The school in Goa closed for summer vacation on 19th April and was to reopen on 4th June, which was also considered by this honorable court while passing the order dated 8/4/2024. My lords, may I just take your lordships to that order where your lordship had intervened the parents, the children in the chambers for about 2 hours. 2 hours, my lords. Your lordship is well aware. And this considered order came to be passed, which is at page 34, my lords. Page 34, 6th point, my lords. The children are permitted, may I, my lords? The children are permitted to be taken by the mother to Goa to attend the classes to be held till the vacation commences. During the first 2 weeks of the vacation, from 19/4 to 4/5/2024, the children are permitted to stay at Goa with their mother at the house where they have been presently residing. The husband is permitted and expected to go to Goa and meet the children. The wife shall permit the husband to meet the children. It is expected that the whole family will stay together in Goa. For rest of the 3 weeks, in the latter part of the vacation, from 5/5/2024 to 26/5/2024, the wife shall stay at Bangalore. The husband, as agreed by him, shall make arrangement for stay of the wife and ensure that all usual facilities to live comfortable life during the stay will be made available to the wife. The stay of the wife shall be in the vicinity of the house of the husband. The husband shall also make arrangement for transportation and tickets of the wife to come to Bangalore and stay for 2 weeks. During the stay of children at Bangalore, the children shall stay with the husband at husband's place. The wife shall have the right to visit the children at the husband's place, and the husband shall allow the wife at all times when she wants to meet the children. Plus, contrary to this order, though after this status quo is taken and because of the status quo, the husband continues to enjoy the company of the children, even to this day, the mother is outside the court. She is at the beck and call of the father, where he permits her, and the messages I have produced, just 1 hour visitation, 6 to 7 p.m. every day. And he sits there, monitors the visitation, makes sure the kids don't even talk properly to the mother, does not permit her to take the children even for a lunch on their birthdays or her birthday or Christmas or any of the festivals. Just 1 hour, my lords, at his beck and call.
They've been invited.
And there are a lot of video cameras installed in the place, and she is confined only to the living room. And he makes sure he gives one or the other video games to the children purposely to distract them so that they don't talk to the mother properly. This is what is happening and continuing as of when I'm submitting. Even yesterday, the visitation was only 1 hour. She used to stay in an Airbnb place where this court had told to make arrangements. And there are messages where he has refused to pay. So now she is at the mercy of one or the other friend. And then now again she is back to an Airbnb, and her mother continues to support her. Because the father has refused. Even in the mediation, it was the same thing. We did try and attempt the mediation, and she did agree that if the husband continues to support me, pay the rent and other things, because he's financially well affluent, I do not mind shifting to Bangalore. And since his alternative prayer in the custody petition is granting visitation rights 50% of the vacation and on the holidays, my lords, that's exactly what she said I'm okay to give him. Monday to Friday, the kids can continue to stay with her. Friday to Sunday, the kids can go to the father. And every vacation, I think both the parents can enjoy 50-50%. However, the father flatly refused to provide any maintenance, due to which the matter could not be settled. And my lords, this is exactly what the grievance of the mother is. Her custody of the children were taken away only because of the status quo order given by the Supreme Court. And your lordship is well aware, after chamber interaction, the mother was permitted to take the children and go to Goa and hand over the kids only on 4/5 for 3 weeks. 4/5, she hands over the kids. 8/5, the matter comes before the Supreme Court, obviously because it is also stated that this arrangement is in the nature of consensus. We did not feel it appropriate to file a caveat because we never thought they will go for a special leave petition. And that's exactly what happened. He approached the Supreme Court and and obtained a status quo order by virtue of which the kids continued in the custody of the father, which is definitely not right, my lords. The academic year of 2024, as per the family court order, having already spent itself, the kids have to rightly go back to the mother, where they can continue their education in Goa. And since all are permanent residents of Goa, my lords, that would be an appropriate arrangement till the custody petition is. In fact, my lords, there is a transfer petition also filed for transfer of petition of GNWC to Goa. And there is a stay of proceedings of the custody petition as of now. And only after culmination of these proceedings, the transfer petition would be taken up.
Just want to.
I have not finished, Madam. One just, please, I have just not finished. Plus, I produced the school fee receipts at 25, page 25, 26, 27, 28, and also a certificate which is available in the records, Lords, seeing which your lordships had said that the kids have to go back to Goa and made such an arrangement on 8/4/2024. So my humble prayer to your lordship is the kids should be handed over back to the mother so that they can go back to Goa and continue their education.
The word as patient.
You want to,
I'm extremely sorry, my lords.
I just want to.
I'm extremely sorry.
say it by
Monday,
saying-
Monday, come Monday.
Monday, my lords. Plus 2:30 at Monday.
My lords, we posted for orders also, my lords have heard us. We have in fact even given a detailed.
I
list
would
of dates.
definitely like a 5 or 10 minutes.
All Monday.
It's that feasible.
Date 2:30.
Lordship, instead of Monday, can it be 12th, Lordship?
49.
Can it be on 12th if possible, instead of Monday?
We are bound by the Supreme Court's time.
Lordship, I will leave it to your Lordship if it's possible on the 12th.
12th, all.
Grateful, Lordship. I'm so grateful. Thank you.
My lords, 12th would be on Wednesday, my lord.
Yes.
15th is where all right, whatever your lordship.
15th is,
The direction as per that, 6 weeks, my lords.
Preferably
Your
6
lordship said
we
that.
had rolled that 4th April.
No, my lords, March 15th,
Then we will not grant.
March 15th, my lords.
Lordship, it's,
Because the order was passed on 30th of January,
30th January.
30th of January, my lords, 6 weeks.
date of, Lordship, my
No,
only
that was
submission-
for the writ petition.
Lordship,
which
our
was-
only submission is,
It was just a
Fine.
formal objections that I had filed.
12th was the
Lordship may
date
just have it on
weekend.
12th.
Go before the Supreme Court and get the extension.
Plus Monday, anytime I'm okay.
10th.
Then Monday.
Yes.
Grateful, my lords.
Afternoon.
Grateful.
Whenever you.
Oh, my lord, may keep it at 2:30 first, Monday?
Grateful, Lordship.
My lords,
Number 49, my lords, on
What do you want?
request on Monday.
What is it about?
Monday what time?
My lords, I am not made a party in a writ petition, though I was a party before the Tahsildar. An order is secured against me without making me a party. We filed a review, reviews also dismissed, therefore we are here in appeal before this court. Now the Tahsildar is to restore the entries.
Yeah.
An order passed without being made a party, though I was the original complainant before the Tahsil. Second prayer, my lords, may not be maintainable.
Take chance on 14th.
14. Please, lords, may I request on 12th, my lords, if it is not 14th, there is some difficulty. 12th, my lords. I'll take my
All
chance.
let take chance.
Great,
Well,
great.
Q for 14.
My lord, serial number 54, my lord. 54, my lords.
Yes.
Office subjection is there. Kindly grant 1 week time.
That's serial number 59, Madhu, the threat of alienation. I've enjoyed a interim order throughout in the trial court. The trial court has refused to extend the interim order on misapplied judgment, my lord. The division bench of this honorable court has said that the commencement of proceedings is from the date I issued the.
What do you want?
I don't Monday, sorry.
Monday.
Great.
Serial number 63.